Lordship, I wish to mention item number 5. I'm appearing on behalf of Teto Taba.
Item number
5, yes.
5.
Hmm.
Yes.
I'm appearing on behalf of Teto Taba, petitioner. Connecting council to auto station.
What do you want?
You also matter will be listed after 2 weeks.
2 weeks. Okay, item number 5. Huh? Yes, State Council. Yes. On a prayer made on behalf of Sri Teto Taba Learned Council for the petitioner, for the appellant, matter is adjourned by 2 weeks. Sri B. Picha, Learned Standing Council. RD is present.
Obliged.
Obliged.
Here, my lord, the challenge has been made to my lord impure order, my lord, dated 26/2/2024, passed by the my lord Central Administrative Tribunal, Guwahati, my lord. Lordship will find at page 40 at page 73, my lord.
What is your grievance?
Grievance is, my lord, a direction has been given by the my lord Kate, my lord, at page 73, my lord. To my lord, by relaxing the recruitment rule, my lord, the respondents are to be, my lord, absorbed in the department, my lord. Absorbed in the, my lord, in the CAG, my lord. Lordship will kindly see at paragraph, my lord, 20, my lord, page 73, my lord. And rule does not provide, my lord, for absorption, my lord, of the deputation, my lord. Deputation is, my lord.
Okay, we issue notice at this stage. Third, Sri R. Saikya, Learned Council for the petitioners, correct?
Yes, my petitioners, my lord, Union of India, my lord.
And how many of you are there?
3, my lord.
Petitioners who have put to challenge an order dated 26/2/2024, passed by the Central Administrative Tribunal, Guwahati bench in so-and-so, whereby the private respondents herein are directed to be considered by relaxing the rules in question. Full stop. It is submitted that the aforesaid direction is not permitted by the rules. Correct? Let notice be issued, returnable by 6 weeks. 3. No. Let steps be taken for there are state yes, government council. Government council.
I will inform them.
No, in the court, whose name can we record? Any government council. Sri or B. Miss so and so, huh? Public works, there is a standing council or let it state council accept notice on behalf of respondent numbers 12, 13, and 14.
12, 13, 14, my lord.
12, 13, and 14. What about 15, 16?
My debt to my lord.
Huh?
My lord, the state will represent, my lord, up to 19, my lord.
12 to 19.
Yes, my lord.
12 to 19. Huh? Let extra copies be served upon him by her, huh? By tomorrow. Let steps be taken for service of notice upon the respondable 1 to 11 by registered post TTD. Steps within 2 days.
My lord, I have an interim, my lord, prayer, my lord, for Stay of the matter.
Three, thank you. Learned counsel for the petitioner, pray for an interim order.
Because these posts are earmarked for the direct recruitees, my lord.
By submitting that the post in question, in question are earmarked for direct recruiting. Full stop. Considering the above, we direct that till the returnable date status quo as on today be maintained.
Okay.
Yes, Mr. Vairam, you'll take notice on for the respondents 11 to 19.
Yes, sir.
नाम लिखिए दीजिए.
Copy दे देगा.
Please give extra copies.
Obliged.
We made it returnable by 6 weeks.
Right.
May it please your lordship. My lord, it is a jail appeal. However, your lordship, I have only received the judgment copy, your lordship. No any application annexed with the judgment. And so far, your lordship, there are almost 600, 96 day, 600, my lord,
This delay.
96 day of delay. So, your lordship, I have come across the judgment, your lordship. No doubt, your lordship, appeal has to be heard on merit, on limitation, it has not to be dismissed. But some reason has to be, your lordship, given by the jail authority or the applicant, your lordship. And here in this case, your lordship, LEC legal aid counsels are there, not the amicus. If it is amicus, then jail authority or the applicant.
So
So
it
now,
has been filed through what?
appeal,
Filed directly from the jail.
yes, your lordship, it is, your lordship, I have received only, your lordship, judgment copy, not even any application annexed with the judgment. Your lordship. And it's a POXO case, your lordship.
We will not insist on the formalities in a jail appeal. We'll appoint a legal aid counsel and delay part, as you know, would be liberal in a criminal.
Yes, your lordship. Victim,
But we'll follow the formalities.
Yes,
We'll have an amicus legal aid counsel, okay. Though this appeal has been registered on the basis of a letter dated 25/2/2025 received from the member secretary, Arunachal Pradesh State Legal Services Authority within bracket APSLSA, Itanagar, whereby a certified copy of the impugned judgment has been enclosed, comma, the Sriti, the learned APP
Yes.
has submitted that there is a delay
yes, your lordship.
in preferring the appeal, full stop. He has, however, very fairly submitted that though he may not have serious objection to the aspect of condemnation of delay, comma, there has to be some prayer for such condemnation.
Yes.
Full stop. Para, the aforesaid submissions would be considered at the appropriate stage. Full stop. Para. Since there is none to represent the appellant and this appeal itself has been registered on the basis of a letter from the member APSLSA, we appoint
Punishment is for 20 years, my lord.
We appoint Sri J. Dini, who is an appellant legal aid counsel, to appear for the appellant. First of let copies of the documents be furnished to him and the matter be listed for admission after 2 weeks. Let the name of the appointed legal aid counsel be reflected in the cause list.
Yes, sir. Obliged. your lordship.
Okay, same issue, Lordship. There is delay of 619 days, Lordship.
Okay,
Office is different, Lord. Different office, Lordship.
okay. Same, huh?
Yes, Lordship.
T18 হবে, এটা হচ্ছে PP হবে, না? Ago to 25th February 2025. Was it 25th February? Letter? Same letter. Same delay is there?
Yes,
Okay,
Lordship.
same there. We appoint whom? Miss, no? We appoint Miss Anne Duncan, huh? Okay, okay. Okay, will come after 2 weeks, showing her name in the call list.
Deeply obliged.
Item 4. This was the 19 matter.
Yes. My lord, in this case, what has happened, your lordship, there was a hearing of this hearing, the matter was heard and this court was pleased to exercise 391, my lord. So by exercising 391, the learned
Additional evidence.
additional evidence, and your lordship, this court was called for your lordship, the status. So far, how many witnesses has been examined? And I've gone through the record, your lordship, 14 witnesses has been examined and 1 left, your lordship. So, your lordship, that may be awaited. So it may matter may be listed after 3 weeks, your lordship.
We'll grant 4 weeks.
Yes, your lordship.
3T, yes, you're there?
I on behalf of Dioka,
Okay, we understand now. The parties are represented by their respective councils. Para? 3T at a Learned additional PP has submitted that in this appeal, an order was passed by this court in exercise of powers under section 391 of the CRPC for record evidence, recording additional evidence. Full stop. He has submitted that accordingly evidence of
Witnesses
have been examined.
examined, 1 is yet to.
Out of 14, 1 or out of 15, 1?
No, your lordship, out of 15, 14 done, only 1 remaining.
Accordingly, out of total number of 15 numbers of witnesses, 14 have been examined and only the deposition of one is to be recorded. Full stop. Para, in view of the aforesaid submission, we had this matter. Yes, anything?
Yes, lordship, he's saying
Yes,
there was
actually,
two.
there are 2 witnesses has been
Okay.
examined still, actually, not one.
Out of 15,
Hmm.
13 or 14.
Yes, my lord, it's there, the report itself, your lordship. It's there in the record, your lordship.
14, there is about 14, full stop. When is it? Last of kidding. In for the matter, the hearing of this appeal is adjourned by 4 weeks to enable the learned trial court to complete the deposition of the remaining
Yes,
witnesses.
sir.
Which the remaining?
Yes, yes, yes. Oblige, your lordship.
Much good.
My application. My lord, I would like to mention item number 34. This may be kindly, my lord agent. My lord, in this case, the court has instructed to my lord obtain the proceeding under criminal case against the petitioner. Now, I have confirmed that my lord, the case has not been disposed of, my lord. So this may be listed after my lord 3 weeks.
Yes, Education Department. Three, C. Modi, learned counsel for the petitioner, has informed that the connected criminal case has not yet been disposed of, and he accordingly prays for an adjournment. Para also heard Sri T. Tagum, learned standing counsel, Education Department. Para, in view of the above, the petition is adjourned by 3 weeks.
My lord. All right.
Your Lordship, item number 7 may be adjourned for today.
7,
Yes, Your Lordship.
on behalf of Laji.
No, Your Lordship. I'm on behalf of B. Sharma, Your Lordship.
V. Sharma.
Yes, Your Lordship. For filing rejoinder, Your Lordship.
Okay.
And the
You want to
matter
file
may be released
rejoinder?
after 2 weeks, Your Lordship.
Okay. What is your name?
Onitik, Your Lordship.
Onitik.
Yes, Lordship.
Sri Onitik, learned counsel for the petitioner, has submitted that rejoinder affidavit would be filed, for which he prays for, and is granted 3 weeks' time. Full stop. Ms. Basar, the learned state counsel, is present. Yes.
Deeply obliged.
Your Lordship, I beg to mention item number 11. I'm
11.
appearing on behalf of A.K. Singh, petitioner. State that just recently filed affidavit in opposition. We have some more time to file affidavit in reply.
Okay. What is your name?
C. Tajo,
C.
appearing on behalf of A.K. Singh. Your Lordship.
Sri C. Tajo, learned counsel, appearing on instruction of Sri A.K. Singh, learned counsel for the petitioner. Same. 3 weeks. for
Obliged.
rejoinder. Why did Rama said, huh? 3 weeks. State counsel.
May I please, Your Lordship?
Yes.
Your Lordship, I beg to mention item number 26, Your Lordship.
Hmm?
26, Your Lordship.
26?
Yes, Your Lordship.
Yes.
Your Lordship, in this case, Your Lordship, as per direction of this honorable court, I have taken justice service upon the respondent number 5 and 6, or 6 and 7, Your Lordship. Your Lordship, will be filing affidavit with regard to that, Your Lordship. Need some more time.
26.
1 week, Your Lordship.
Yes, Mr. Tara? What is your name?
He may enjoy, Your Lordship.
T?
He who may enjoy, Your Lordship. Yes,
It is not, you are not on record.
yes, Your Lordship.
Oh,
My mistake.
Emenjo. Okay.
Yes, Your Lordship.
Sri Emenjo, learned counsel for the petitioner, has submitted that pursuant to the order of this court, justice service
Yes,
upon the respond number
6 and 7.
6 and 7 has been affected. Full stop. He, however, prays for some time to file an affidavit in proof of such justice service. Full stop. Has paid for least after 2 weeks to enable filing of
One,
such
if possible, Your Lordship.
1 week.
Yes,
Can you do it within 1
yes,
week?
Your Lordship. Sir.
Least after a week to enable filing of such affidavit.
Highly obliged.
Lordship, I would like to mention item number 23 and 24. Your Lordship,
Sure.
here we have to file affidavit, Your Lordship. 3 weeks may be granted, Your Lordship, to file affidavit.
You have informed the other side.
Yes, Lordship.
Separate, 23 and 24, both three matters will.
Both, yes, Lordship.
Get order exactly, yes, huh? On the prayer of Ms. Basar, the London State Council, matters are adjourned by 3 weeks.
Lordship.
3 weeks to enable filing of affidavit in opposition. Yes. Sir.
Okay.
Is there any interim order, madam?
Lordship, I'm for the petitioner. Petitioners instruct me to withdraw the case, Lordship.
Okay, what is your name?
Takar Bagang, Lordship.
T. Badam.
Yes, Takar Bagang.
Yes, respondent
I'm representing 8 and 9.
and Mr. Topping. Heard Sri T. Bagam, learned counsel for the petitioner. Also heard Sri S. Tapin, learned senior law advocate for the official respondents. And you are A. Ribe.
A Reve.
A. Ribe, learned counsel for the respondent, number 8 and 9. What's the para? Sri Bagam, the learned counsel for the petitioner, has however submitted that he has instructions not to press this
Yes,
writ petition.
yes,
Full
writ
stop.
petition.
The aforesaid prayer is not opposed by the learned counsel for the respondents. Para. In view of the above, writ petition is dismissed as not pressed. There is no interim.
There is
order
an
pending.
interim, your lordship.
Interim order passed earlier stands vacated.
Deeply obliged.
My lord, I'm sorry for intruding, my lord. It appears the government mentioned item numbers 23, 24, and
You have been informed.
my junior was informed. There's a stay order, my lord, that
Okay,
Yeah.
yeah, we asked.
Yes, yes, yes.
She said there is no stay order.
I beg your
We had
pardon.
asked.
yes.
Interim order passed earlier to continue till the next date of this thing.
Of that.
Inadvertence, no motive.
No, no. In fact, she came and told me now.
Yes, got the matter.
One judgment from the matter.
What about yesterday's judgment? We had passed a judgment yesterday. In
My lord, that I tried to find in the online, it was not
why
uploaded.
it was uploaded yesterday itself.
Trying
A business.
item number 19. My lord, para number 5.
There are private respondents.
My
Here,
lord.
okay.
My lord.
Otherwise, we could have disposed of this matter. Will issue notice. Heard Sri H.K. Jammu, learned counsel for the petitioner who has approached this court by invoking Article 226 of the Constitution of India to challenge an order dated 28/3/2025 passed by the learned District Consumer Dispute Redressal Commission, UPA, whereby the complaint of the respondent numbers who? Two. Is it two? Two.
Opposite party number 1 and 2.
Respondent number two. In this proceeding, he is respondent number two or not?
My lord, we are respondent number 1.
No, not you, the complainant.
Complainant. Complainant is respondent number 2. My
Respondent
lord.
number two was allowed. Full stop. The learned counsel has urged that the limited ground under which this petition has been filed is non-availability of the appellate forum due to the retirement of the earlier presiding officer, whereafter no new presiding officer has been appointed. Full stop. He has submitted that a litigant cannot be left remediless. And in this connection, he has also referred to a judgment dated 7/1/2022 of the Honorable Madras High Court in so and so, available. In the said case, an observation was made that in case the consumer forum is not functioning or has become defunct, then writ petitions may be entertained by the High Court and not otherwise. Full stop. This court is also of the prima facie view that a litigant cannot be left remediless, more so when the statute itself provides for an appellate forum and such remedy is not being able to be taken recourse to in view of the fact that there is no presiding officer. Para? Let notice be issued, returnable by 4 weeks. Sri S. Tapin, learned senior government advocate, Arunachal Pradesh accepts notice on behalf of respondent number 1. Let extra copies be served upon him by tomorrow. Let steps for service of notice upon the respondent numbers
2, 3, 4,
2, 3, 4,
5.
and 5 be taken by registered post with AD. Steps by tomorrow.
My lord.
Para. Sri Jamo, the learned counsel, prays for an interim order by submitting that what course of action? Something has been initiated.
My lord, the
Has
next
any-
day is on 30th.
Huh?
This 30th.
Execution proceeding has been initiated.
Yes, yes.
Sri Jammu, the learned counsel has submitted that execution proceeding has been initiated.
Yes, my lord.
And the same is required to be stayed. First of considering the aforesaid submission and the materials on record, it is directed that until further orders, the operation of the impugned order dated 28/3/2025 passed by the learned district so-and-so commission, UP, shall remain suspended.
My lord.
In case number 2, in case number 7, shall remain suspended.
Case number
Full stop.
EA number 1 of 20.
It is however made clear that if in the meantime, the appellate, the state commission is made functional, the interim order would cease to have any effect and the petitioner can approach the appellate forum, appellate commission, a state commission with a prayer for stay of the impugned judgment.
My lord, highly obliged. My lord.
Yes.
My lord. My lord, this writ petition is challenging against the issuance of LPC 10 notes by the respondent number 4, that is Deputy Commissioner Lord Siang, during the operation of status quo passed by himself. Lordship, here
10 numbers of LPCs have been
10 number of LPC
issued in whose favor?
respondent, private respondent.
Who are you? How are you agreeing?
I am a petitioner. I am aggrieved. There was land dispute between the respondent and petitioner and the respondent.
During that dispute, the LPC have been issued
Yes, Lordship.
in spite of there being a status quo order.
Lordship. It is status order is page number 38, Lordship.
38.
Yeah, they are violating 1998 Government of Arunachal Pradesh Secretary land notification also. By beyond he has acted beyond the jurisdiction. Only deputy commissioner can issue only 50,000 square meter, that is 5 hectares, not more than that. But respondent number 4 has issued 80,000 square meter, exceeding
But this
50,000.
order of 15/7/2021 at page 38, is it still in operation? This is an order of
No, sir.
2021.
Since matter is still pending,
This
since-
is,
since the-
this is in operation.
operation, and matter is still pending, Lordship. And Lordship, here, we have also submitted, the petitioner submitted a representation to the respondent authority for cancellation, but they are sitting over the request made by
No,
the petitioner.
what, after issuance of the LPC, why do you pray for a stay of the LPC? Will anything be done against you now?
Lordship,
You are aggrieved by issuance of the LPC.
Lordship,
We can issue notice, but you are also praying for a stay.
yes, still Lordship.
Why stay?
Is there, because of this, this LPC, the dispute land, if we go through this, the Blaze customary code, then it's become infractions, because he has having an LPC, respondent has.
Oh.
Lordship,
Yes. Your number.
Arnabam, Lordship.
We Arnabam counsel for the petitioner.
May I please, Your Lordship?
Yes.
Your Lordship, I am appearing for respondent number 1 to 6, Your Lordship. Your Lordship, according to this annexure,
I, page 38,
wait, yes, annexure,
impugned order, what, which one?
the notification which he is referring, Your Lordship, notification issued by the Land Management Department, Your Lordship. May I read, Your Lordship? The last 4th line from the bottom, Your Lordship.
Page
Yes,
Page-
page 68, page 68.
68.
Yes, 68 of the petition. May I read, Your Lordship? Land possession certificate up to 5 hectares shall be issued by DC on the strength of NOC to be issued by the DFO and also on fulfillment of other conditions prescribed by the Office Memorandum event number of 19 December 1988, Your Lordship. Your Lordship, maybe the NOC has been obtained or may not be obtained. We'll have to ascertain that, Your Lordship.
But what about the
We'll have
status quo order?
That order is of 2021, Your Lordship.
21 years.
Yes.
No, that is what we had asked him. Whether
And also
20
dispute is lying in the.
21 order is still valid.
Yes,
He
Your
says
Lordship.
that it is operative.
Operative. Lordship, since matter has not decided, dispute has not decided yet, so it's under operation,
Dispute is before the local authority. Your
local authority. That is pending,
Lordship.
Lordship.
Not before the DC, Your Lordship. DC has not also prescribed for the.
38 order is passed by whom? Mr. Navam?
Lordship,
38, page 38 order is passed by whom?
pays the deputy commissioner.
It is the DC's order,
See, Lordship.
madam.
See, in the pendency of this order, how they have issued LPC beyond his capacity, Lordship? This is total arbitrary and violation of the rule of law.
This appears to be from the deputy commissioner.
Yes. Your Lordship.
And where is the order of issue of the LPC? Which order? Page?
Page number, Lordship, here, kindly turn to page 54, Lordship.
LPC issued.
Page number 54, LPC issued 80,000 to respondent number 7, private respondent number.
80?
54, 54,
54.
54. Yeah, total area 80,000 square meter, beyond his capacity. And next page, Lordship, here again, two number of 80,000 square meter.
This
To
page,
respondent number 7.
page 54 is one of the respondents here,
Yes, Lordship.
and he was a party to the dispute.
Yes.
Otherwise, Your Lordship, short date may be given, Your Lordship. We'll take instruction. on it. Till then, status quo, interim prayer may not be allowed.
No, Lordship. Interim is very necessary here because
She is saying it is not necessary.
no, it's necessary for me because of this, especially of this LPC, my land has been damaged and my land has been illegally, occupied by them, undetermined. So when this LPC is operative, then I totally there will be infectious. If Kavha conduct also there will be infectious. So unless this court so under 226, this court has the capacity and
Yes, Your Lordship,
the jurisdiction to intervene and issue notice along with the interim order. Possible.
may I, Your Lordship, notification dated 16 March 1999 doesn't say that LPC cannot be
Mr.
issued.
Nabam,
Lordship.
the LPC is of 2023.
Yes.
223. That's right. Through RTI, we came to know
How
24.
do you stay an order of 23 in the year 2025?
Lordship, 2024, we came to know this LPC.
Maybe you have come to learn recently, but these are orders of 2023 September. You cannot stay this.
Lordship,
We
It-
can issue an notice on the
issue
interim
notice,
prayer.
issue
Interim
notice.
prayer.
Issue notice.
Third, Sri R. Nabam, learned counsel for the petitioner, who has approached this court with a grievance that LPC has been issued to the private respondents. Number,
Private 7, 8, 9, 10, and 11.
private respondent was 7 to 11.
7 to 11.
It is the case of the petitioner that such LPC could not have been issued inasmuch as there was an order of status quo passed by the concerned Deputy Commissioner,
Respondent number 4.
Lower Siang District, inasmuch as there was a land dispute between the petitioner and the said respondents. He has, in this connection, drawn the attention of this court to the order dated 15/7/2021. Para, let notice be issued returnable by 6 weeks. Ms. P. Sangeeta, learned State Counsel, accepts notice on behalf of respondent numbers 1 to 6. Madam,
Yes, Your Lordship.
1 to 6. Let extra copies be served upon her by tomorrow. Let steps be taken for service of notice upon the respondent number 7 to 14 by registered post PTD, steps by tomorrow. Para. Sri Nabam, the learned counsel, prays for an interim order
Interim order.
by submitting that LPC could not have been issued while an order of status quo is pending. Full stop. On the other hand, Ms. Sangeeta has opposed the said prayer by submitting that LPC can be issued if no objection certificate is given by the concerned DFO
Yes.
and it is not known and nothing has been disclosed in this regard in the petition. Full stop. Para. Though prior facade, a case appears to have been made out in view of the order of status quo dated 15/7/2021, which Sri Nabam, the learned counsel, has asserted to be in operation as on today, this court cannot overlook the aspect that the LPC was issued way back in September 2023. Therefore, instead of passing an interim order, let notice be issued on the interim prayer, which would be considered on the returnable date.
Lordship. Lordship, in the meantime, respondent number 7 to 11, they will not do any activity. Other status quo order may pass, Lordship. At least status quo order.
No, it's from 23 September.
Yes, Lordship. Here, in this case,
We'll just say status quo as on today, how will it make any difference?
Lordship,
We'll
here,
give you a returnable date. Let this matter be listed on, tell us 6 weeks, 4 weeks. We'll make it 4 weeks.
Lordship,
Give a date, Mr. Nabam. 4 weeks. Today is what? 21st, 1, 2, 3, 4, on 18th. 4 weeks exactly on it, 18th of June.
high level.
All right.
Yes.
Lordship, I'm appearing on behalf of DSGI M. Kato for responding.
Use the microphone, madam.
Lordship,
Use the microphone. Yes. Yes.
Lordship, I'm appearing on behalf of M. Kato, DSGI, for respondent number 1, 6, 7, 8, and 9. And Lordship, due to his health issue, he could not appear.
Health issue. What has happened to him? He was fit and fine yesterday. Yesterday he was fit and fine. What has happened to him? Party last night?
No, Lordship.
No. How are you so confident?
Lordship, he was sick yesterday also, but his health worsened today.
Okay. It was in a lighter vein. Okay. He is not well. So what is the 19th matter? Madam will fix a date. Okay. Next week.
Yes, Lordship.
Do Sri J. Jini, learned counsel for the petitioners is present. There is a prayer made by Miss
Yasmin Gao.
Miss so on behalf of Sri M. Kato, the learned Deputy AGL, praying for an adjournment on health ground. In view of the above, matter is adjourned, will be listed on. We give a date on the next in the next week on 28 May.
Obliged.
Yes.
Lordship, this writ petitions, Lordship, I'm challenging the order of the Deputy Commissioner. This order has been passed in violation of APP Unauthorized Occupation Act. Now, Lordship,
Affidavits exchanged.
affidavit has been exchanged.
Tell us, can it be taken up for final disposal?
Yes, Lordship. Only the Lordship, only a small issue is involved in this case, Lordship. Whether the Deputy Commissioner has accorded opportunity of being heard when the appeal was taken up. This is, in fact, the second round of litigations before your
What do
Lordship.
they say? Is it disputed or are they
They are saying that the lane which is under dispute.
the issue of giving an opportunity? Is it disputed or is it admitted?
They say that I have been accorded opportunity, Lordship. But I say that I have not been accorded opportunity, Lordship.
That is-
Clearly, from that order itself, it will be apparent that no opportunity was accorded to me, Lordship.
Affidavit, what do they say on this point in the affidavit?
Your Lordship, basically the petitioner is claiming the plot of land through this order dated 20th July to 2005.
Hmm.
It's annexure 2, Your Lordship,
Hmm.
of the writ petition, which is a provisional land allotment.
Hmm.
If I read, Your Lordship, in anticipation of the approval from government, a plot of land measuring 40 by 30 meter, total 200 square meter in between so and so, sketch map so and so is provisionally allotted. Where, as per the Act, Your Lordship, there is no provision of provisional
There is
allotment.
no scope of any provisional allotment.
Yes, Your Lordship.
In anticipation.
Yes, Your Lordship. Moreover, Your Lordship, the limit for allotting land allotment is, government allotment land is 1,000 square meter only. Here, it is 1,200 square meter, Your Lordship, which is way beyond the prescribed limit, Your Lordship.
So if no right was accrued by the initial order, where is the scope of giving you an hearing?
Lordship, in fact, what had happened is, Lordship, they have issued one order, Lordship, for eviction, Lordship. Lordship will find that order.
Even, Your Lordship, this provisional land
No,
allotment
if
was.
you are ready, you can take up this matter for disposal, okay?
Lordship, page number 36, Lordship. Issue is only one small issue is involved in this case, Lordship.
Take this.
Page 36, Lordship.
Just-
Initially, this
Tell
particular
us the facts, what are the facts?
Lordship, I'll just apprise the facts. Lordship, the petitioner while working as a extension officer in the year 1994, Lordship, in the
How many
Department of
petitioner?
Social
One
Welfare
petitioner.
Department. Petitioner.
One
Lordship.
number of petitioner, one petitioner.
One petitioner.
He was working as extension officer.
Extension officer, Lordship. In the year 1994, Lordship.
Which department?
Lordship, Social Welfare Department, Lordship.
Yes.
She occupied a plot of land measuring 1200 square meter, Lordship. 1200 square meter, Lordship.
Occupied.
She has occupied, Lordship.
Square meters.
Lordship, around and I have applied for an allotment, Lordship. Will find it that annexure 1, page 27, Lordship.
27.
27, Lordship. Lordship, I have applied for provisional land allotment, Lordship. Prayer itself is very clear, Lordship. Prayer for the provisional land allotment.
Annexure 1.
Annexure 1, page 27.
34 2005.
Lordship.
When did you occupy this land?
Lordship, 1994 I have occupied.
95 for itself.
Lordship, 94 itself I have occupied.
And you had made this application in 2005.
Lordship, I have applied this application in the year 2005. Now next, annexure 2, page 29 is the provisional allotment, what my learned friend was containing, Lordship. This was issued by EAC, Lordship. Now, after getting this provisional land allotment, Lordship. Page 29, annexure 2.
'27.
Page 29. Lordship. It's dated 20th July 2005, Lordship. This provisional land allotment was accorded to me, Lordship.
Yes.
For 1200 square meters, Lordship. Between police barrack and circuit house. Now, same year I have constructed a kacha house, Lordship. Same year. Now, after construction of that house, Lordship, I was posted in some other district, Lordship.
Yes.
Since I was posted in some other district, Lordship, now some of the people, they started encroaching upon my land, Lordship. Now that 1200 square meter was reduced to 700 square meter. Since there was frequent encroachment, Lordship, now it was reduced to 710 square meter, Lordship.
710.
Lordship. So in the year 2013, Lordship, I have taken a preventive measure by erecting a barbed wire, Lordship, around my plot, 2013. Now, while erecting this barbed wire, suddenly one person, Lordship, who is the private respondent in this case, Lordship, Ashok Nabam, Lordship, who is represented by the council, Lordship, today. He started to appear in my plot of land, Lordship, claiming that that plot of land belongs to him, Lordship.
Who, respondent number?
Private respondent 4, Lordship.
Claim that the land
belongs to him, Lordship. Then the dispute started, Lordship. Now,
this dispute started in 2013.
Lordship. Accordingly, a complaint was filed before the magistrate. Lordship will find that complaint, the summon letter issued to the private respondent at page 30, annexure 3, Lordship, page 30. Now, on the basis of my complaint.
You are Yade Gumro.
Yes, I am here.
You had lost the complaint.
Complaint before the magistrate, Lordship. Now, here the private respondent was summoned on 15th February 2000 to clarify the standing along with the supporting documents.
Yes.
Now, instead of appearing before the magistrate to clarify his stand, he filed one FIR against me, Lordship. Lordship will find that FIR at annexure 4. Page number 31. He filed one FIR against me, Lordship. alleging that I have encroached upon his land and certain properties were damaged. Now accordingly, charge sheet was filed, trial was commenced, and I was discharged from the charges, Lordship.
In the
Page
trial,
number 32, Annexure 5 is the order of the London CGM, whereby I was discharged from.
five two. 5-2.
15, 2018, Lordship.
5-2,
GR
it is
case.
5-2.
5-2, yes, Lordship. 5-2, 2021, Lordship.
Yes.
Lordship, kindly come to page 35, Lordship. Now after I was discharged from the allegation that was alleged against me.
Same case which was instituted on the basis of the FIR laws on 12/2/2018.
Lordship, FIR, the FIR that I have shown, Lordship, Annexure 4, Lordship.
Page 31.
Page 31, Lordship.
Yes.
Now I was discharged from the charges alleged against me, Lordship. Since I was discharged from all those charges, Lordship, page number 35, Lordship, that particular documents is not legible, so I've typed it out, Lordship. That typed copy will find at page 35, Lordship. Now 2021, after duly informing the Deputy Commissioner, since that disputed lane was still no construction was taking place, Lordship, I intimated the Deputy Commissioner for construction of a house, Lordship. After duly informing the Deputy Commissioner, I started constructing the house. Again, disputed started, Lordship. Now again, the private respondent, he filed one complaint before the Deputy Commissioner. Now, on the basis of the complaint filed by the private respondent, the impugn notice, Lordship, 7th May 2021 was issued, Lordship, for eviction, Lordship. Lordship will find it Annexure 7, page 36, Lordship. Now here they have the authority concerned, they have invoked
What is your name? Yadanabam.
Lordship, page 36.
Yadanabam, okay.
Now, therefore, you are hereby directed to stop the said construction forthwith and remove the said structure within 7 days for the issue of this notice, failing which the said structure will be evicted by district administration and the cost of eviction will be imposed on you, Lordship. Now, without serving any notice, so cause, Lordship, this notice was served upon me, Lordship. Now, being aggrieved by this notice, which was served without any so cause, directly directing me to remove my structure within 7 days, Lordship, I have served one notice, Lordship, to reply to the notice, Lordship. Page 37, Lordship. Now, this very notice, now they are contending that through this notice, I was accorded opportunity of being heard, Lordship. Now, this reply to the notice was, in this particular notice, my contention was that the very notice that was served upon me, it's illegal, Lordship. They cannot serve me, Lordship, without so cause, Lordship.
Yes.
Now, subsequently, Annexure 9, Lordship, page 40, Lordship, another notice was served upon me, Lordship.
Page
40, Lordship, Annexure 9, page 40. Operating portion, Lordship, is page 41, Lordship, last paragraph, Lordship. Same order was passed against me, Lordship. Invoking APP, Eviction Unauthorized Occupation Act 2003, Lordship. Last paragraph, Lordship, will find. Now, therefore, in view of above, you are directed not to construct house on the site and you are prosecuted as per section APP, Unauthorized Occupation Act 2003, to remove the structure pillar on and you said within 10 days from the issue of this notice, failing which the same shall be evicted without further notice and the cost of eviction shall be imposed, realized from you. Now being agreed, Lordship, page 42, annexure 10, I have filed one appeal before the Deputy Commissioner, who is the appellate authority, Lordship. Now the state officer has been passing this impugn order without according any opportunity of being heard, Lordship. I filed this appeal, Lordship. Page
Yes.
42, Lordship.
Yes.
Now, since this appeal was not taken up by the Deputy Commissioner, being aggrieved, I have approached before this Honorable Court, Lordship.
This petition,
Writ petition.
this petition.
Writ petition. First round of writ petition.
Oh,
Lordship.
earlier you had,
Earlier also I have approached before this Honorable Court. Page 50, Lordship, annexure 11. Lordship.
appeal was not even taken up.
Not being taken up, Lordship. Now, by this order of
You-
this Honorable Court,
You
Lordship,
filed WPC what? WPC number?
WPC number 242 of 2021, Lordship.
Page?
Page 50, Lordship, annexure 11, page 50. Now, through this order, Lordship, the Deputy Commissioner was directed to take up the appeal, and in the meantime, that the impugn order that was put to challenge before this Honorable Court was stayed, Lordship, till the appeal was disposed by the Deputy Commissioner. Now, this very order, Lordship, passed by this Honorable Court was duly communicated, page 52, Lordship. We have communicated it to the Deputy Commissioner, Lordship.
Fifty?
4, Lordship. 54, annexure 12.
Yes.
Now, upon receipt of our Lordship, order of this Honorable Court, Lordship, page 56, annexure 13, Lordship. This order was passed by the Deputy Commissioner, Lordship. Agreeing to the fact that no proper procedure was followed, so that matter was remanded back to the state officer to take corrective measures as per the court order, Lordship. Lordship will find it that very direction in the last paragraph of that order, Lordship. In view of the above, state officer Pake Kesang is directed to initiate necessary corrective measures as per court order.
Yes.
Now, the matter was remanded back to the state officer for taking up the case afresh, Lordship. Now, Lordship, annexure 14, page 57, Lordship. Now, this is a communication letter from the state officer to the Deputy Commissioner, whereby the state officer has clearly declined to take up the matter afresh, Lordship. Page paragraph 4, Lordship. Here clearly the state officer says that, may I say sorry that I will not be able to prepare the pertaining to the appeal case summon petitioner order for the appearance before the appellant authority. He was directed to take up the case afresh, Lordship, since there were certain allegations against the state officer not according opportunity, Lordship, which is in violation of Act 2003, Lordship. Proper opportunity, Lordship, has to be accorded, Lordship. Section 4, Lordship. Now, upon returning of this particular case to the Deputy Commissioner, Lordship,
Yes.
the Deputy Commissioner again took up the appeal, Lordship, and passed this impugn order, Lordship, without according any opportunity of being heard to the petitioner's hearing. On its own, relying on the communication letter given by the state officer, this appeal was disposed of, Lordship. Now, Lordship, I am being aggrieved by this order of the Deputy Commissioner.
Appeal
Why
has been dismissed. Appeal has been rejected.
has been dismissed, Lordship. No opportunity was accorded, Lordship. No hearing was, opportunity was given. On its own, Lordship, on the basis of this particular communication letter of the estate officer, this order has been passed. So why I am being aggrieved, Lordship, I am before your Lordship. Now, section 4, subclause 1 of Act 2003, Lordship, clearly Arunachal Pradesh public premises, eviction, unauthorized occupation. As per the sections, Lordship, mandatory notice, so cause has to be given to the person against whom the eviction is to be carried out, Lordship. That was not accorded to me, Lordship.
Which section? Section?
Section 4, Lordship, subclause 1, Lordship. If the state officer is of the opinion that any person is in authorized occupation on the public premises and that he should be evicted, the state officer shall what has been used, Lordship, issue in the manner hereafter provided a notice in writing, calling upon all persons concerned to show cause why an order of the eviction should not be made, Lordship. Now, the order that I have been showing, Lordship, those orders has been directly been passed for eviction, Lordship. No show cause notice was ever passed against me, Lordship. Why I am agreed, Lordship.
Yes.
Now, this section 12, Lordship, that has been filed against the order of the estate officer, Lordship. There also, Lordship, Deputy Commissioner ought to have given me that opportunity at least of being heard, Lordship. Since I filed one applications that I've shown, Lordship, that application ought to have been heard, then pass that order, Lordship. That was not accorded to me, Lordship. So my humble prayer is, Lordship, this order of the Deputy Commissioner has to go, Lordship, and then remanded back and the fresh appeal has to be taken up. That's my limited prayer.
No, you are making a twofold kind of a submission. You have taken us to section 4 of the Act, which envisages issuance of so-called notice before any order of eviction is taken up. Your contention is that that was not followed. And that you have filed the appeal. Appeal has also been disposed of without giving you an opportunity of hearing. So now you pray that the matter may be remitted back to the appellate authority. Now, if you are challenged, you made a preliminary challenge to the preliminary by the state officer, which envisages issuance of show cause. You are trying to make out a case that no show cause was there. Then what would be the objective of remitting to the Deputy Commissioner?
No, since the Deputy Commissioner's order was passed without affording any opportunity to me, Lordship,
That will
solely,
come subsequently.
Lordship, solely.
That will come subsequently. But you have an additional, the first ground is that the first order of eviction was done without following section 4. That is not within the domain of the deputy commissioner. That was in the domain of the state officer, correct? Now, this can be one of the points which should be taken up with the appeal.
Appeal.
Now, appeal has already been disposed of without hearing it. That is a different ground so far as your challenge to the appellate order is concerned. But you are also making a challenge to the preliminary, the initiation of the proceeding itself.
These are all, Lordship, supplementary arguments that I'm putting
So,
forward.
will a remand to the deputy commissioner serve your purpose, or will it bring the litigation to an end? Perhaps not.
Lordship, since the appeal, in the appeal, since as Lordship has rightly pointed out, in the appeal, I have taken the plea saying that the to impugn order that has been passed by the state officer is without according any
Now,
opportunity,
what
without any
will
so cause.
the deputy commissioner do? He will remit it back to the state officer.
No, Lordship, he can take up the appeal on his own, Lordship.
Appeal, he allows the appeal. He says that you should give a show cause notice. Then again, it goes back to the state officer, gives show cause.
Lordship,
Ultimately, one more step will be, if you are urging that the first initiation by the state officer was not in accordance with law or there violation of section 4, then that itself would be a ground. Because remitting back to the deputy commissioner, even if assuming we have made out a case, it will not bring an end to the proceedings.
Lordship, here in Lordship, I think in my prayer, Lordship, I have prayed for quashing of this two impugn order passed by the state officer also. I think I will just check, Lordship. Yes, Lordship, I have challenged that also.
State council?
Yes, Your Lordship.
State officer should have given him a notice.
Your Lordship, in my humble understanding, Your Lordship, if Your Lordship may peruse section 6 of the said act, Your Lordship.
Yes,
Power to remove unauthorized construction, etc.
yes.
1. No person shall erect or place or raise any building or any movable or immovable structure or fixture. And subsection 2, Your Lordship, where any building or other movable structure or fixture has been erected, placed or raised on any public premises in contravention of the provision of subsection 1, the state officer may serve upon the person erecting such building, other structure or fixture, a notice requiring him to either remove or to show cause why he shall not remove such building or other structure or fixture. By reading this, Your Lordship, he has the power to directly order for the eviction, Your Lordship.
Please read to where any building.
Where any building or other immovable structure or fixture has been erected, placed or raised on any in contravention of the provisions of subsection 1, the state officer may serve upon the person erecting such building or other structure or fixture a notice requiring him either to remove or to show cause why he shall not remove such building or other structure or fixture from the public premises within such period, not being less than 7 days.
Lordship,
Yes.
here
Yes,
also,
please.
Lordship, notice is required, Lordship.
Yes.
Yes.
Then please
Here
read
is-
again. And on the omission, if we continue,
No less than 7 days as he may specify in the notice, and on the omission or refusal of such person either to show cause or to remove such building or other structures or fixtures from the public premises, or where the show cause is not in the opinion of the state officer sufficient, the state officer may by order remove or cause to be removed the building or other structure or fixture from the public premises and recover the cost of such removal from the person aforesaid as an area of land revenue.
see, this, firstly, section 6 cannot be read in isolation. it has to be read in consonance with section 4. And from what you had hinted at the starting of the argument, though you have not made elaborate argument as yet, you have said that the first order by which he was given certain right, that order was not in accordance with law. Firstly, you say that it was a provisional allotment.
Yes, Your Lordship.
And that too in anticipation of approval.
Yes, Your
There
Lordship.
is no provision
Yes, Your
for any provisional allotment in
Yes,
the act.
Yes, Your Lordship.
So it would not amount to an allotment.
Yes, Your Lordship.
So it would make him in the status of an unauthorized occupant
Yes, Your Lordship.
under this act.
Yes, Your Lordship.
But he stands on a slightly better footing, that he has one order of 27/2005, may not be a legally sound order, but he has something on the strength of which he is occupying.
Moreover,
But let us take your argument
yes,
and term him as an unauthorized occupant.
yes, Your Lordship.
Then you want to remove him. You have the powers under this act
Yes,
to remove him. Power says that yes, if you find it unauthorized. 4 says that you issue notice. 6 says that you can issue show cause as well as ask him to remove. If he doesn't do, then you take action.
Yes, Your Lordship.
Now,
Yes, Your Lordship.
now that is the preliminary point. Thereafter, appeal has gone. Appeal he was not heard. We do not know whether in the appeal he was heard or not. We have not been heard. Maybe you have some records to show that he was given an opportunity of hearing. We do not know. But his contention is that even in the appellate stage, he was not given any opportunity. So, if the second contention is correct, the very easy way for the court is to remand this matter to the appellate authority to give him a hearing.
Yes, Your
But
Lordship. Can do them, yes.
the first point which he is trying to raise
Yes, Your Lordship.
regarding the validity of the action of the state officer, that would still remain open.
Yes, Your Lordship.
Do you want this court to make any opinion on the first point, or do you want that the matter should be remanded to the appellate court, appellate authority?
May it be remanded to the appellate authority. That will be better option, Your Lordship.
No, regarding his submission that in the appeal, since this appeal is a part of the statute
Yes, Your Lordship.
which he had approached.
Yes.
But his contention is that yes, I had taken all the points, but somehow the appellate authority did not give me a scope of hearing.
Yes,
It was disposed of, which could not have been done. We can remit it back. But are you in agreement with his with his statement of facts that he was not given any hearing in the appellate stage?
Yes, Your Lordship. Yes, Your Lordship. We have not stated that we have given any opportunity.
And no instructions that
Yes,
he
Your-
was given any
As per
opportunity.
our affidavit, Your Lordship.
Yes. Yeah, for the private respondent.
Yes, Lordship. Lordship, since the petitioner is agreed with the action of the respondent authorities, Lordship, I have nothing to submit. But so far as the ownership is concerned, Lordship, I have an objection, Lordship.
No, we may not say anything at this stage on the ownership. What are your papers regarding ownership?
Lordship, Lordship, I have been issued a provisional land possession certificate, which is a private, Lordship, which is my private land. Whereas she has been claiming over the land on the strength of a provisional land allotment order, which was issued by circle officer, who is not a competent.
But your land documents pertain to the same plot of land.
Yes, Lordship.
If it is the same plot of land, it's a state council, how can it be and government land? How can you invoke this act?
Your Lordship, since this is a newly created district, Your Lordship, the government, we are in need of the, this one, for
So if
establishment of
the
this.
private respondent is saying that this land belongs to me, and petitioner says that no, that land belongs to me on the strength of 27/2005 order, then there will be a private dispute. It
Yes,
cannot be an unauthorized possession of this act will, whether this act will come in at all.
In fact, Lordship, the first notice was issued on the strength of my complaint, Lordship. It's already reflected in the order.
But that complaint, can it be taken up under this act? eviction of unauthorized occupants. Who is an unauthorized occupant?
That complaint can't be taken in this act, Your Lordship.
See, what is the meaning of unauthorized occupant 2(7) of the Act? Before you read 2(7), you read again the name of the Act. What is the name of the Act? The Arunachal Pradesh public premises.
Yes, Your Lordship.
It has to be public premises.
Yes, Your Lordship.
So this unauthorized occupant, the entire concept has to be vis-a-vis a public premise. It
Yes.
cannot be the private land of any individual. So again, then you read the definition of unauthorized occupants in subsection
7.
7.
Yes, Your Lordship.
2(7). Please
Yes.
read.
Unauthorized occupation in relation to any public premises means
Any public premise. So first requirement, it has to be a public premise. Yeah, then means
the occupation by any person of the public premises without authority for such occupation, and it includes the continuance in occupation by any person of the public premises after the authority, whether by way of grant or any other mode of transfer under which he was allowed to occupy the premises has expired or has been determined for any reason whatsoever.
what is the basis of the first of 7/5/2021? Mr. Jamie, 7/5 is the first order,
Lordship, yes,
Yes,
Lordship.
Your Lordship.
7 May 2021,
7 May, page 36.
Yes, Your Lordship.
page 36.
36. Yes. Seven five was issued by whom?
Your Lordship, state officer, Your Lordship.
Lordship, state officer.
7/5 was issued by the deputy commissioner.
No, Your Lordship, there has been a mistake on part of the state officer. It should have been state officer, Your Lordship. Because, Your Lordship, if you see the copy to section on 1, we have already marked it to PA to DC for information, please. So it may be,
State officer.
yes, Your Lordship.
State officer issues this notice under what provision of law?
They have not clearly mentioned the act here in this.
To state
but-
officer,
Yes, Your Lordship.
to assume jurisdiction,
Yes, sir.
it has to be a land which is government land,
Yes, Your Lordship.
government premise.
Yes, Your Lordship.
But this appears to be on the basis of a complaint by the private respondent,
Yes, Your Lordship.
saying that he is the owner. On the other hand, petitioner is saying that he is the owner. So there is an ownership dispute.
Yes, Your Lordship.
Whether the state officer could have resolved this ownership dispute, number one.
Under this act, no, Your Lordship.
Under this act,
No.
no, otherwise also, there is no mechanism for the state officer to decide title.
Yes, Your Lordship.
And to assume jurisdiction under this act, the first requirement is that the land has to be public premise.
Yes, Your Lordship.
So there is a jurisdictional error.
And Your Lordship, in our affidavit also, we have not.
What is the present status, Jenny,
Lordship,
of the land?
Lordship, it is status quo has been maintained, Lordship. Since
Means-
there is a stay in this,
Who it is under whose possession?
it's in my possession.
But if it-
Since that barbed wire was constructed and house
it
was
is still
also
under-
constructed.
It is still under the fencing of barbed wire fencing. Is it still there?
Lordship, as per instruction,
And what do you say?
In the year 2021, I filed an RTI notice with regard to the status of land, whether there is any land on it. And as per the RTI information notice, there is no land in favor of the petitioner.
No, that is a different aspect.
that is,
That is a different aspect. He may illegally occupy your land. For that, you have remedies in law to evict him. But we are asking, what is the present status of the land? Who is under occupation? Are you under occupation of the
This
land?
was if there is an interim order from this honorable court, it's under our occupation.
Her occupation.
Yes, as per the interim order.
Then this simple remand to the deputy commissioner perhaps will not be in the interest of justice. The invocation of the act itself appears to
Lordship,
be erroneously done.
otherwise, Lordship, what I have humbly praised, Lordship has kindly observed that Lordship, this particular act cannot be invoked.
Yes,
Lordship.
cannot be invoked.
So entire proceedings can be set aside first and maybe directed both the parties to approach the appropriate forum. Lordship. Can go.
No, your rights to approach the civil court or whichever court is always there. And we
Lordship.
can also make an observation that pendency of this litigation would be taken into consideration in case limitation aspect comes in. Because when you're given the complaint when 21 only. I think that would be the best order.
Lordship, yes, 21.
Pardon, Your Lordship.
I think we have to interfere and leave to the parties to avail their rights and remedies for ascertaining the title over the land, as well as to take up eviction proceeding if the private respondent so desire.
Yes, Your Lordship.
You have not taken up that point, whether this application of this act was itself erroneous.
Lordship, that I have not taken. Fairly submitted.
Okay. Please have your seat.
Lordship.
Your name?
K lawyer.
For R4.
Yes, sir.
Taking into consideration that the writ petition is of the year 2021 and also in view of the subject matter and as also agreed to by the learned counsel for the parties, this writ petition is taken up for disposal at the admission stage itself. Not since admission stage. Para. As per the facts projected in the petition, the petitioner, who is an extension officer in the social welfare department, had occupied around 1,200 square meters of government land. Full stop. Subsequently, he had applied for the allotment of the said land, and on such application, the circle officer P/Kisan, East Kameng district had passed an order dated 27/2005 granting provisional allotment of the 1,200 square meters of land. Full stop. It was, however, stated in the order that the same was done in anticipation of the approval from the government. Para? On the strength of such allotment, the petitioner had constructed a kacha house and thereafter, due to his service, he was transferred and posted in some other districts. And in his absence, there was encroachment over the aforesaid land, reducing the area to about 710 square meters. Full stop. On noticing the same and to preserve the land, the petitioner had constructed a barbed wire fencing over the plot of land in the year 2013. Full stop. However, when the said activity was going on, the respondent number 4 had raised a dispute by claiming ownership over the said plot of land. And accordingly, the petitioner had accordingly filed a complaint before the authorities, in which on 8/2/2018, the respondent number 4 was summoned by the EAC. However, it is the case of the petitioner that the respondent number 4 did not appear in the said proceeding, and on the other hand, had lodged an FIR in the Tepa police station, which was registered as SEPA case number 15 of 2018 under section 447/427/506/341 or no, not 341, 34 of the IPC. Full stop. Para. The charge sheet was laid after the investigation. However, the learned CJM, on examination of the materials, by order dated 5/2/2021, had discharged the petitioner in the criminal case registered as GR number 15 of 2018. Full stop. After such discharge, the petitioner had submitted an application to the Deputy Commissioner in May 2021, informing regarding construction of a house. Full stop. Immediately thereafter, almost at the same time, a notice was issued to the petitioner on 7/5/2021 by the Estate Officer, Pake Kesan District, directing him to stop the construction and remove the same within 7 days, failing which the construction, failing which the structure will be evicted by the district administration at the cost of the petitioner. Full stop. It is the contention of the petitioner that the said notice was issued without any show cause notice or any opportunity afforded to him. Full stop. The petitioner had accordingly submitted a reply through his counsel on 9/6/2021. Full stop. Thereafter, on 5/8/2021, another notice was issued to the petitioner to remove the construction. Full stop. Para. Having no other alternative, the petitioner had preferred an appeal before the deputy commissioner, who is the appellate authority. Full stop. As the said appeal was not taken up for consideration, the petitioner had earlier filed WPC 242 of 2021 before this court, which was disposed of by this court via order dated 11/8/2021 with a direction for consideration of the appeal, with a further observation that till such consideration, the impugned order would remain stayed. Full stop. The aforesaid order of this court dated 11/8/2021 was communicated by the petitioner to the appropriate authority, and pursuant to the same, the deputy commissioner had passed an order dated 16/8/2021 whereby the matter was remanded to the estate officer to take corrective measures. Full stop. However, the ADC cum estate officer had issued a communication dated 18/8/2021 declining to take any action by citing certain reasons. Full stop. Subsequently, while the order dated 28/2021 passed by the deputy commissioner, the appeal was rejected. Full stop. The petitioner has contended that such rejection was not preceded by any hearing or opportunity granted to the petitioner. Full stop. Para. It is the aforesaid action which are the subject matter of challenge in this writ petition. Para. I have heard Sri J. Ginny, learned counsel for the petitioner. Full stop. I have also heard Sri so learned state counsel for the official respondents and Sri K. Loya for the respondent number 4. Full stop. Para. Sri Ginny, learned counsel for the petitioner, has submitted that the initial order of the estate officer dated 7/5/2021 was itself in violation of Section 4 of the Arunachal Pradesh Public Premises within bracket eviction of unauthorized occupants bracket close Act 2003, which envisages issuance of notice to show cause against order of eviction. He has submitted that a bare perusal of the said order dated 7/5/2021 would reveal that no such show cause notice was issued prior to the impugned action, and therefore the said order is void ab initio. Full stop. He has submitted that the criminal case instituted against him on behalf of the respondent number 4 had culminated in an order of discharge dated 5/2/2021 passed by the learned CJM, and therefore it stands established that the petitioner has the right over the land in question, and the allegation of encroaching the land of the respondent number 4 is without any basis. He has also submitted that the petitioner's attempt to get his grievance redressed by approaching the appellate authority was also initially did not bear any result, as the appeal was not considered and the same was done only after the intervention of this court vide the order dated 11/8/2021 passed in WPC 242 AP of 21. He has submitted that though the Deputy Commissioner as the appellate authority had initially passed an order dated 16/8/2021 by remanding the matter to take corrective measures, the state officer had declined to take any action by citing trivial grounds. Full stop. He has seriously assailed and he has raised serious objection to the manner by which the appeal has been rejected by the impugned order dated 28/2021, which has been done without giving any opportunity of hearing to the petitioner, who was the appellant. Full stop. Para. The learned counsel for the petitioner has drawn the attention to section 12 of the aforesaid act, which provides for appeal, and there is a requirement to give the aggrieved parties an opportunity of hearing, and such appeal cannot be disposed of in a mechanical manner. Full stop. He has submitted that it is a basic principle of natural justice to give an opportunity of hearing, and in this case, there is apparent violation of such principles. Full stop. He accordingly prays for interference with the impugned action. Para. 3. On a per contra, Sri so-and-so learned state council has submitted that the foundation of the case of the petitioner is erroneous, inasmuch as the order dated 27/20/2005, which is relied upon by the petitioner, would not confer any right upon him. Full stop. By referring to the said order passed by the circle officer, the learned state council has submitted that the circle officer is not vested with the jurisdiction to give allotment. Full stop. He has also submitted that there is no he has also submitted that the act in question does not provide for provisional allotment, that too in anticipation of approval. Full stop. He accordingly submits that no right of any nature was vested upon the petitioner over the aforesaid plot of land. Full stop. He has accordingly submitted that the impugned orders have been rightly passed. Full stop. The learned State Council has, however, been very fair in admitting that don't say it, don't say it. On the aspect of requirement of a so-called notice as per the act in question, the Learned State Council has referred to section 6 of the said act, as per which issuance of so-called notice is not mandatory. Full stop. He has submitted that it is in the interest of justice for which the impugned action has been taken. Para. As regards the disposal of the appeal, while the order dated 28/2021, the Learned State Council has, however, fairly admitted that such disposal appears to have been done without giving an opportunity of hearing, and therefore, at best, the matter can be remanded back to the appellate authority for a fresh consideration by giving a scope of hearing to the affected parties. Para. 3. Lawyer, the Learned Counsel for the respondent number 4, while endorsing the contentions advanced by the Learned State Council, has submitted that the land in question has been duly allotted to the respondent number 4, over which the petitioner had made unauthorized encroachment. And it is in this context that the complaint was lodged by him. He has submitted that the orders of eviction of the petitioner and removal of structures are in accordance with law and in the interest of justice. Full stop. Para. The rival contentions advanced by the Learned Counsel for the parties have been duly considered, and the materials placed before this court have been carefully examined. Full stop. The foundation of this case rests upon an order dated 27/2005 passed by the circle officer, whereby provisional allotment of the land in question was granted in favor of the petitioner. Full stop. While it has been stoutly argued on behalf of the state that there is no provision in the Act for granting provisional allotment in anticipation of approval, it is not in dispute that indeed such an order was issued by the circle officer. Full stop. Whether by such an order any right can be vested upon an individual is an issue which would require determination, even if it is held that no right appears to have been vested, by the said order, comma, it is not in dispute that till 2018, 2013, the land was not only under the possession of the petitioner, but he had also made barbed wire fencing over the said land. Full stop. At this stage, the stand of the private respondent taken is also crucial. Full stop. The private respondent number 4 has claimed the land to be his own. Full stop. If the ownership of the land is claimed by the private respondent, which is also a claim of the petitioner, then the very application of the act in question would be doubtful. Full stop. As the name says, the Act of 2003 is for eviction of unauthorized occupants over public premise. Full stop. Public premise has been defined under section 2(4) of the Act, which reads as follows. 2(4), quote. Similarly, unauthorized occupation has been defined under section 2(7), which is extracted here in below, both. Para. The issue regarding requirement of giving show cause notice and opportunity before evicting from unauthorized, evicting from public premises of a person in unauthorized occupation is laid down in section 4 as well as section 6 of the Act. While section 4 requires issuance of a notice to show cause against order of eviction, which has been relied upon by the learned counsel for the petitioner, comma, the learned state counsel has relied upon section 6, which provides for taking an action without even issuing a so cause notice. Full stop. In the opinion of this court, opinion of this court, section 6 cannot be read in isolation, and section 4 has to be read along with the said provision. Full stop. Though a person may be an unauthorized occupant as per the meaning of the Act, such unauthorized occupation can be removed only by issuing a prior notice before any orders of eviction. Full stop. However, in the facts of the present case, the said issue may not be very relevant as indicated, and it may not be relevant. Full stop. This court has already indicated that so far as the land in question in this case, so far as the land in question is concerned, the respondent number 4 has claimed ownership over the same, and accordingly, a complaint was lodged of encroachment of the land of the respondent number 4 by the petitioner. Full stop. As already indicated above, on the other hand, the petitioner has laid ownership of the plot of land on the strengths of the order dated 27/2025. Full stop. Whether the aforesaid order dated 27/2025 would vest any right is questionable, it is not in doubt that the land in question is not a public premise, and therefore, in the opinion of this court, there would be no application of the Act of 2003 in question. Full stop. Therefore, the initiation of the proceeding under the said act by the impugned order dated 7/5/2021 is itself without any jurisdiction and therefore is interfered with. Full stop. Consequently, the orders passed on 7/5/2021, followed by the appellate order dated 28/2021, are set aside. Full stop. Sarah? The setting aside of the aforesaid act is only for the reasons indicated above, and the aspect of the ownership of the rival parties are not the subject matter of this list, and no opinion has been expressed in that regard. Full stop. Consequently, either of the aggrieved parties can approach the appropriate forum of law for declaration of right title and interest and recovery of possession in accordance with law. Full stop. Petition accordingly stands allowed in the manner indicated above. No order is to post. Who will write, huh? You write two things. State government, by Reza, he has filed affidavit in opposition dated 26/5/2023. Okay, and while you refer to lawyer, he has filed affidavit in opposition dated 7/8/2024. Take it up from the representative. You take the book while extracting.
Please. My lord, in this case,
This. Yes.
so for the exchange of pleading is concerned, it has not completed. But it is not because of the negligence of the petitioner, but my lord, the private respondent who has once appeared in the years 2023, thereafter private respondent has not been appeared. Therefore, my prayer before this honorable court today is that this matter may be picked for the final argument, and in the meantime, it may be reflected that this can be proceed ex parte against the private respondent number 6. Because, my lord, in this case, the bond of contention between the petitioner and the private, yes,
6 was served.
is already served. My lord, by the order dated 5/May/25, it revealed that the respondent already received the, my lord, petition copy in the years 2023,
You will have it for admission hearing.
my lord. And in the meantime, my lord,
You have filed affidavit, Mr. Room.
my lord, I have filed. And I have received the affidavit in opposition filed by the Eastern, my lord. And I prepare to file reply within
Rejoinder, okay.
my lord, rejoinder, my lord.
On the prayer of Rishi Modi, learned counsel for the petitioner, 3 weeks' time is granted to file rejoinder affidavit to the affidavit filed by the department represented by Sri T. Tagum, the standing counsel.
My lord, it may be also reflected kindly that the in absence of the private
No, that is already
responsibility.
declared. There is an order.
Well,
You take note of the order. We can give you the order.
all right.
8/5/2025. Please keep a note. Service upon the respondent has been held to be complete.
All right.
You just refer to this order.
Deep level.
This matter pertains to deduction of the salary within 1 year of retirement. My lord.
Deduction of salary?
Yes,
Not deductions.
deduction,
Excess payments.
excess payment. They purportedly
The department claims that some excess payment was made to you.
yes, my lord.
And they
Only,
are trying to deduct that.
only on the ground that he has not passed the accounts examination for executive engineer. But in the subsequent, my lord, they have also taken the same ground. Then in our rejoinder, my lord, the audit and pension department have given a clarification saying that he need not to pass the accounts examination. My lord.
You need not.
Need not, my lord.
Madam, you are for the government.
Lordship, yes, senior government advocate is coming, Your Lordship, he will appear, STP.
Happiness coming.
Can you take this up for disposal today?
Yeah, a small thing, and then item 9
Every
also.
matter you say small, and when it starts, it becomes big.
Okay, Lalan Kato. Deduction one, no? Okay, okay, additional affidavit. हम लोग rejoinder में.
So, Tapin? Yes. What do you say?
Yeah, Lordship.
Are you in receipt of my rejoinder? Kindly see my rejoinder. My lord. My rejoinder pays 97. My lord. No, no, we have given our rejoinder, we filed it. Well, the rejoinder says, yes, sir. Kindly give me the.
Give him a copy of the agenda, we'll have it when.
Well, the poor fellow is starving, you know, almost 1 year.
Not starving.
Without pension, my lord. Kindly.
Without pension?
Without pension, my lord. Next item is for the pension, my lord.
Yes.
Because
Why
of
why
this.
you held up the, why have you held up the pension?
Pension, yeah, almost.
How much is the excess payment as per you, without even going to the merits of the case projected by Mr. Tara? How much is the over payment, extra payment?
8 lakhs.
Lordship,
By letter dated 5/8/21, they have written that he need not to pass the account because there were.
How much is the amount?
Amount is 8 lakhs.
8 lakhs.
8 lakhs. They have deducted 4,33,138 rupees.
Already.
Already deducted. So because with that, we put into challenge, my lord.
Pension is held up.
Pension is
otherwise,
set up
Lordship,
only
raise-
because of this
raise
proposition.
Service benefits have been already released, Lordship. Only
That he's starving, he's saying.
only, Lordship.
He's starving.
My lord,
If you don't have bread, you can have cake.
Well, the paradox of this country in a lighter vein is that you
Like the Queen had said, if they do not have bread, give them cake. They can have cake. So you must be having the cake, not the bread.
No, but that's why adding to a lighter soft, Milord, the greatest paradox of this country is you can openly pee, but you cannot openly kiss. Is the situation that I'm facing this. Please read this.
386.
Yes, it's here.
This is there. Candidate, page 97. They have clarified, my lord, that the petitioner need not to
Who represents the audit department?
state government.
You see that letter?
97.
Now, if that is the stand of the audit department, could you have taken the impute action of deducting? Have you taken instructions on that letter? What has been written in that letter?
My lord, I read. On re-examination, the service book of. Oh, sorry. Sorry, my lord. I extremely sorry, my lord. This is an example letter written in one of the case, Mr. Tagun Ketan, my lord, that has been brought on record. So the fact is, on re-examining the service book of incumbent, it appears that the passing of the departmental account exam for AE, executive engineer, had been made mandatory with effect from 10/0/2001, wide order number so and so. As the officer had already been promoted as executive engineer before cutoff date of passing departmental account exam, the question of passing departmental exam for AE and EE and recovery of excess draw of pay and allowances therein does not arises as mentioned in our earlier observation, white letter number so and so. This. And I was also promoted in 2000.
So far, recovery is concerned in view of this rapid massive case.
White was that para 7 and 10, that principle will apply.
And side Abdul.
But why is there no stay order in your case?
It is the gracious.
No, but what post were you holding?
I was executive engineer in
Then
2000.
Rafiq Masih will not be applicable.
But principle will come.
No, principle will not come. It has been explained only for grade 3, grade 4, not for higher level
Correct.
officers.
I understood.
That is only out of grace, that's grade 3, grade 4, and that too you should not have any role in the error. If
Correct,
you are
correct,
any role
right,
you have, you are the one for whom the error has.
Absolutely correct. Absolutely.
But executive engineer Rafiq Masih per se will not. be
It will not. But why we are pressing on this is.
But if you are making out a case.
Yes.
That the reason for withholding is
Was
not
not
sustainable
passing-
in law.
Correct.
And that passing of this audit thing is not mandatory.
Mandatory. That is the only small issue.
What do you say on this mandatory thing?
Lordship, here, Lordship, so far the recruitment rule is concerned, Lordship. For promotion from J to Lordship, assistant engineer, Lordship. That in rule itself, it's a prescribed, Lordship. Though the rule is not placed here, Lordship. The account examination has to be passed to be promotion, Lordship.
Okay.
And that part, Lordship, within a period of 2 years, it has to be.
But what about the letter of this audit department, so far as another incumbent is concerned? How do you address that?
I press it to kindly see page 97.
You take instructions on that. Monday we are fixing.
Right.
Okay.
Right.
If you have a precedent of taking a similar kind of an action.
Okay.
Petitioner should not be deprived of.
Correct. They cannot resile also. They stand taken by the government.
Now the extra payment which they are terming to be an extra is on what account? Is for holding the higher post or what?
No, but only on the account that I have not clearly passed the account
No,
examination.
the extra payment, otherwise.
Higher post.
Otherwise, we would have,
Higher post.
you would have got on passing the exam only.
Only for passing of the exam because.
Then if you have not passed, how do you get?
No, that there are OMs and all, which says that state government OM is also there, which says that executive engineer and above post need not to pass the account examination.
No, that is different aspect altogether, whether you have passed the accounts examination.
Correct.
But the amount which has come to you is only on account of passing the account examination.
No, Milord, no.
Then for what? The 8 lakhs is concerned, 8 lakh amount is concerned, has been paid because of what purpose?
No, but I was assistant engineer. Thereafter, in the year 2000, I was promoted to executive engineer.
Okay.
When the IPS was sent to the audit department for verification of my pension paper, the audit department wrote back to the department saying that you must deduct this much of money from the petitioner. And because of that particular order, the department has gone ahead with deducting.
No, will it trace back to the aspect of your promotion also?
My promotion also.
From assistant engineer to executive engineer?
No, executive engineer to, I have cleared my accounts examination for assistant engineer. There is no quarrel on that. After I was promoted to the executive engineer and then to the superintendent engineer, when I superannuated in 2024, on these particular, there was an increment, higher pay scale. So then, according to them, the audit department.
Is this increment directly connected with passing of the examination?
Yes.
Then?
No, madam. There is an exemption for executive engineer and superintending engineer. They need not to sit for the account examination.
Okay, you take instructions one day. Okay. First, Sri T.T. Tara. Learned counsel for the petitioner.
97.
Sri S. Kapil.
This.
The learned senior government advocate, Arunachal Pradesh. Sri Tara, the learned counsel, by drawing the attention of this court to the rejoinder affidavit, has submitted that for another incumbent who was similarly placed, the benefits were given, whereas for the petitioner, the benefit which was given has been sought to be recovered.
97.
That too from his pensionary amount. Full stop. Para. Read up in the London State Council, praise for, and is granted time till Monday to obtain instructions on this issue. Para. List accordingly on. We'll have it on.
Well, kindly make it.
We'll have it on 27th.
Yes.
Okay, one more day.
One more day.
Or 28th, whenever you want. 28th,
27
27th,
is fine.
27th. 27th will be Tuesday.
Tuesday. Well, this is also relating to the pension matters, but due to pendency of a criminal case, my lord, his pension papers was not clear.
I have received the instruction, madam.
And my lord, the criminal case where I was involved, I have been exonerated. So therefore, they cannot withhold my pension anymore, my lord.
You have paid the pension?
No, madam, we have
Only provisional pension they
provisional
paid?
pension, madam.
Okay, they are processing, my lord.
Okay, we can close this then.
Yes.
They close this.
Heard. Three T.T. Tara, learned counsel for the petitioner. Also heard.
T. Wangmo, madam.
Miss so learned state counsel. Full stop. Para. Please have your seats.
Thank you.
The grievance which has been raised by way of this petition filed under Article 226 of the Constitution of India is related to the pensionary benefit of the petitioner. Full stop. The petitioner had retired as the Deputy Commissioner of the Pake Kesang district in the state of Arunachal Pradesh on 31/12/2021. Full stop. However, his pensionary benefits were not finalized. Full stop. It is finalized, and therefore the writ petition has been filed. Para. Sri T.T. Tara, learned counsel for the petitioner has submitted that it appears from the records that such action was on the basis of the involvement of the petitioner in a criminal case being what? What is the criminal case? Have you given any details?
Yes.
Criminal case before
Criminal
the-
case number, my lord.
before the district and session judge, come special judge, PCA, Teju, in SIC paragraph 10, paragraph 10, I'm just put a mark, Spencer. Full stop. He however submits that though at the time of instituting the writ petition, the aforesaid case was on the stage of adducing evidence. Subsequently, the petitioner, but subsequently, the criminal case has ended up with an exoneration,
On 5/5/2025.
with a judgment dated 5/5/2025,
5/5/2025. Correct, my lord, very recent.
whereby the petitioner has been exonerated. Full stop. He therefore submits that as on today, there would be no reason for not finalizing the pensionary as where the finalizing the pensionary benefits of the petitioner and releasing the same to
Correct.
him.
There is no departmental proceeding against me.
Ms. Wangmu, the learned state council has, on the other hand, submitted that though the reasons specified in paragraph 10 of the writ petition was one of the issues which was pending consideration before finalization of the pension of the petitioner. The said issue appears to have been resolved by the aforesaid judgment passed by the learned trial court. Full stop. She has submitted that though affidavit by the responsibles 2 and 3 have been filed in these proceedings, comma, she has very recently received instructions that after the disposal of the criminal case, the issue of pension has been taken up in the right earnest. Full stop. She has placed before this court a communication dated 15/5/2025 issued by the personnel department along with an order dated 16/5/2025 by the department to the Director of Audit and Pension, forwarding the pension papers and service book of the petitioner, along with all the necessary enclosures for finalizing the pension. Full stop. Copies of the copy of the aforesaid order dated 16/5/2025 is also handed over to Sri Tara, the learned counsel for the petitioner. Full stop. Para. This court is of the opinion that since the principal issue regarding finalization of the pension has now been undertaken, as would be evident from the communications placed on record, there is no reason to keep this writ petition pending any longer. Full stop. Accordingly, the writ petition is closed by directing the authorities to bring the issue of finalization of issue of release of finalizing and release of the pensionary benefits to the petitioner expeditiously and preferably within an outer limit of 2 months from today.
Great.
The writ petition stands disposed of. The communications dated 15/5/2025 and 16/5/2025 are made part of the record. Madam, you have extra copies?
Yes, ma'am.
Detail. Wait, I will not take 10 minutes, but I've given list of dates.
IA is by?
I was filed by me, but if your lordship take up the responsibility.
Okay. What is the issue?
My lord, selection process was cancelled.
Oh, yes, it
Yesterday's
matter. Because of ratio.
Yes, ratio.
Okay. Yes, Mr. Tagum.
In fact, my lord, all others, my lord, they
Should
were,
not be a very contentious issue.
they were allowed. The impugn order is at page 92, ma'am.
It is pertaining to the health department.
Health department, my lord. In fact, the
Advertisement-
language you use is from your lordship's judgment in another case, my lord. Same nurse department, nursing.
Nurse department means?
Yes, sir.
Which
There was
is-
another selection process, my lord, that was also cancelled, my lord. My lord had interfered in that case also.
Some last week.
Yes, not last week, my lord, 2023, I believe, my lord.
Well, last week we had passed a judgment on a similar issue.
The similar, that is different, my lord. That also I have.
Okay, doesn't matter. 2023 advertisement
Yes, my lord.
for 75 posts.
Yes.
And you, how many of you are there? 6 numbers.
6 we have come. We are concerned with, my lord, Gyati Taka, General Hospital 07.
Okay, including 7 posts.
Yeah.
Okay. Okay. Thereafter,
Thereafter, my lord, results were declared, my lord. That is
written examination was held on
Written-
18/21/8
my lord,
and 22/8 results declared.
my lord.
Declared qualified for taking the
Skill test, my
skill
lord.
test.
Yes.
What is this OSP?
Objective structured practical examination.
Objective
Structured practical examination.
structured.
Structured, my lord, practical examination.
Okay, thereafter,
Thereafter, my lord, on the basis of the written examination object and OSP results, my lord, declared on 23, my lord. Then, my lord, on 22/8, this was in respect of another district, they filed a complaint. Then 29/8, my lord, Arunachal, my lord, so many associations, they filed a complaint, my lord, there was neither here, neither there. 24/8, my lord, all the recruitment processes were, my lord, put on hold. 24/8. 29/8 reports were called for, madam. On the same day, report submitted by deputy.
you belong to which district?
Lord Subansri.
Lower Subansiri. This particular hospital is in that.
Yes.
Okay. Then,
Then, my lord, report submitted 29/8. There was the categorically, when it's stated examination process was held in a free and fair manner. Then, my lord, that the impugn order is dated 27/2/2024. The only ground is the ratio, my lord. There were other hospitals, my lord. Bakinpardin General Hospital, Pasigat, Alo, General Hospital, Bomdila, Khonsa, Teju, all these, my lord, they were allowed to be completed, my lord. Now they are working now. Our is the ratio only, my lord, 1:3. That also, my lord, there is only some instructions, my lord. It is not in the recruitment rules.
and this, what is this ratio?
One
What
is
is
to
this?
three.
And what is this about? And
That-
the issue which touches,
Yes,
how many candidates, how many vacancies are there?
7 vacancies, 1 is to 3, 21 should have been called. What the selection committee did was, everybody who scored more than 60, they were called. So 35 were called, my lord. It is not that anybody was deprived, my lord. In fact, 35 was called.
As per ratio, 21 should have been called.
Yes. 35 candidates called who obtained more than 60 marks in the written test.
Uh, uh, This, how do you maintain the ratio? Like if you are strictly going by the ratio, 7 vacancies are there.
1
So
is to
you-
3, so
You,
21.
you invite 21 person.
21. For the
Who will be the 21? In accordance with what?
results of the written test, merit.
Merits?
Yes.
Okay. Now, if there are more than one candidate securing the same numbers, then how do you maintain the ratio?
That matter, I'm not very sure, madam.
Suppose for the for the 21st position,
Yeah.
before that, you can manage.
Yes.
2 persons getting, 3 persons getting the same number,
I
they are
understand your
included.
query, madam.
Now, if the last post is vacant and there are 5 numbers of
Yes,
persons
yes, I
securing the same marks, how do you resolve this?
Madam, I am not aware, madam. This is something, madam, they will have to
Yes,
answer.
Mr. Thakur.
In this case, madam, those who obtain more than 60, all were.
No,
called.
that is okay.
They, in fact, all should be called, madam.
All should be called in that case.
For the last position, it can be more than 21 also. Okay, because you cannot deprive anyone if it
Yeah.
comes in the ratio.
Yes.
Okay. And this can happen only for the last vacancy.
Yes, last.
And not vacancy, the
No,
last position in
last
the
position,
ratio.
yes. 21,
Hmm.
21 boys.
And here what decision was taken? More than 60%.
For more than 60%, everybody was called. 35 was called.
During more than 60%
In the written exam.
in. That's called total
35.
35. Okay, we'll come back at 2 o'clock.
Madam.
We'll hear Mr. Taguman try to dictate the judgment today itself.
One judgment by our High Court directly on the point of the ratio, madam. 2019.
You say that the rules do not contemplate maintaining of ratio.
No,
It
madam.
is only a part of the instructions.
Yes, madam. My lord will
Can you please the
Fine.
instructions?
find that in the affidavit filed by the department, madam. 3, 4, and 5.
What is this IA for?
I was for, they have advertised the post again now. That's
Oh, for stay of the advertisement.
the other matter, my lord, I have a stay, madam. This matter I did.
No, where is the, you are referring to the affidavit?
Yes.
Affidavit of file too? Yes, which
Page
page?
106, last page, madam.
106.
106. These are general instructions to conduct written examination skill test. 14 August 2023, serial number 15, ma'am,
100
and 6, man.
106, perhaps of the repetition.
No, my lord, of the affidavit filed by the,
Affidavit file starts with 116.
in my copy, they have given 101. Of respondent number 3, 4, and 5.
No, this is a 4. Yeah.
That's another.
Gyani Natung case.
No, my lord, item number 12, man. Rubu Munya.
I don't know. Rubu. It will affidavit conveys. You have 2 matters or 1 matter? 2 matters.
2 matters.
Same.
The same, my lord. Other one only on the ground that the skill test was not conducted. That is the only ground, man.
Wait a minute.
That can be, my lord, taken up some other day also, my lord, because I have a stay in that case.
Here, which, 106?
106. General instructions
Yes, last page.
to conduct written exam skill test. Serial number 15, my lord.
Just a minute, please.
How the candidate should arrive at what time, all these instructions, how to conduct the exams. Phone
Yes.
cameras, all these are prohibited, all this. Serial number
Yes.
15, my lord. Pass marks for written examination is 50 in all nursing examinations. However, cutoff marks to be set up to maintain 1:3 ratio. That is number of posted candidates. This is the only
These instructions are dated 14th August.
2023.
What is the judgment you want to show?
My lord, 2019 4 GLT 223, my lord.
Two 2019.
My lord, volume 4 GLT 223. Para 29, my lord, directly on.
Aurobindo Rabha.
Para 20, 230.
Para 29.
29, directly on ratio. Page 230.
As regards.
Yes, as regards the non-conformity of ratio of candidates called for interview, though it can be said to an irregularity, but the question is whether certain irregularity itself will be sufficient to vitiate the selection process. It may be mentioned that adhering to certain ratio for calling of candidates for interview is to ensure equitable opportunities to the candidates for assessment, and so that deserving candidates are not unduly deprived of. In the present, it has been noted that the variance ratio is not substantial to be considered unreasonable, hence merely because the ratio has not been strictly adhered, that cannot be a ground for setting aside the recruitment process. In fact, here in this case, my lord, less number of candidates were, my lord, called.
In that case.
Yes, this case, my lord.
Aurobindo case.
Here, my lord, all those who have obtained more than 60 they were called.
You have said 35.
35. Others, my lord, they have been appointed subsequently on the ground that there is no material, my lord, there is no all pervasive material of any irregularity. Same thing for us, except for the 1:3 ratio.
Okay, yes, yes.
My lord, that is the ground we have taken up. That's the only ground, my lord. Because the ratio
Been fair.
instruction, my lord, there we have already.
You have preempted him by saying that he's fair.
I have seen the
Now
affidavit,
he
my
has to
lord.
be fair.
There is nothing in the affidavit, my lord, 2 pages. Sir.
We do not know.
Instead
What
of
did
call-
he take out from his sleeve?
instead of calling 21 candidate, my lord, they have
35
called
were called.
35. My lord. That's a violation of instruction serial number 15, my lord. That's why, my lord, since the public confidentiality is in doubt, my lord, their shade of doubt, my lord. That's why, in order to maintain the public confidentiality and to maintain sanctity of the process, my lord, this selection process, my lord, which has been cancelled.
Anything else?
My lord, that is the basically ground we have taken, my lord. In the impugn order also.
Okay.
I will point out one thing, my lord. The advertisement was initially for 1 year only, my lord. That time has passed. But in respect of the others who have been appointed, they are continuing now, my lord, even after 1 year also.
The tenure was for 1 year.
For 1 year. Subject to, my lord, further.
Well, that we cannot say anything. That
Yes.
will depend on the
Yes.
administration
Authority.
authority.
Yes.
But we can only say that there will be no impediment for your.
Yes, yes.
Yes, please wait. Anything else? Mr. Pai?
No,
Please have this.
just pointing out the pages.
6 numbers of petitioners have joined together in filing this petition under Article 226 of the Constitution of India, challenging an order dated 27/2/2024 passed by the Health and Family Welfare Department, recommending a re-examination of selection process in respect of nursing officers within bracket contractual Gyati Taka General Hospital 0. Full stop. It is the petitioners have taken the ground that such cancellation, such recommendation of a re-examination has been done in a mechanical manner, which has not only affected the rights of the petitioners who are selected candidates, but is also not in consonance with public interest. Para. As per the facts projected on 18/7/2023, the Mission Director NHM had issued an advertisement for filling up certain numbers of posts of contractual nursing officers in various hospitals, including 7 numbers of posts in respect of the Gyati Taka General Hospital 0. The petitioners who were eligible for such appointment had participated in the recruitment process, and the written test which was held and the written test was held on 21/8/2023, and in the results declared on 22/8/2023, the petitioners were held to be qualified for the next stage involving skill test within bracket objective structural practical examination, OSPE, that's OSP. After undergoing the aforesaid examination on 23/8/2023, the results were declared and the petitioners were amongst the selected candidates for appointment for the posts as in question. Full stop. However, just prior to declaration, just a day prior to declaration of the said results, a student union had submitted a representation alleging malpractice, which however was pertaining to another district, namely Upper Subansari district. Full stop. Thereafter, another representation was submitted on 29/8/2023 by the All Arunachal Pradesh Unemployed Nurses Association, whereby certain irregularities were alleged in the selection process. Full stop. It is the case of the petitioners that the allegations were vague and no specific instance was revealed in the said representation. Be that as it may, an order, be that as it may, the Mission Director NHM had initiated passed an order dated 24/8/2023, putting on hold the recruitment process, which was followed by an order dated 29/8/2023, passed by the department, directing the deputy commissioners of the concerned districts to seek report on the report on the recruitment process. Full stop. But this 29/8 of the Lower Subansari, this is not got nothing to do with you. 29/8/2023.
It was written to all the deputy
No,
commissioners.
reports submitted by the deputy commissioner.
Yes, they maybe not in reply to this, but
But it cannot be on the same date.
yes. But there's a report.
No, but Lower Subansari is not connected with you.
Yes, yes.
The petitioners have also brought on record that so far as is the date
Yes,
correctly given, both 29/8.
yes, ma'am. Madam will have a look.
Madam, check the records.
Yes, I have it, madam. Page 86. I checked it, yes.
69 and 86.
Yes,
Both dates are same.
yes, madam. 86, 29 August.
The petitioners have also brought on record a report submitted by the deputy commissioner, Lower Subansari, of the same date, wherein it was stated that the examination was conducted in a free and fair manner. Full stop. However, in spite of there being no adverse reports so far as conducting the examination pertaining to the Jati Taka General Hospital 0, the impugned order has been passed on 27/2/2024 by the department, recommending re-examination of the selection process. Full stop. The ground which was assigned in the impugned order was that the ratio of 1:3 was not maintained. Full stop. It is this action which is the subject matter of challenge in the present writ petition para. I have heard Sri D. Pangi, learned counsel for the petitioners. I have also heard Sri T. Tagum, the learned standing counsel, Health and Family Welfare Department, as well as Ms. Wangmo, learned state counsel. Full stop. Sri Pangi, the learned counsel for the petitioners, has submitted that the recruitment process in which the petitioners, along with other candidates, had taken place for the 7 number of posts in respect of the Gyati Taka General Hospital 0 is concerned, was done by following the due process of law and in a fair and transparent manner. Full stop. He has submitted that all the steps pertaining to the aforesaid recruitment were duly fulfilled, which included a written examination followed by skill test, whereafter the petitioners were declared to be successful for appointment. Full stop. He has also contended that though a student union had submitted a representation on 22/8/2023, the same was pertaining to another district and not concerning the hospital in which the petitioners were found to be eligible for appointment. He has also submitted that so far as the representation by the Nurses Association is concerned, the same was a vague representation without any specific instance of irregularities. Full stop. Fair? The Learned Council has assailed the impugned order dated 27/2/2024, which has been passed not on the ground of any malpractice or gross irregularity, but on the ground that a particular ratio of 1:3 was not followed so far as the hospital in question is concerned. Full stop. He has submitted that the rules holding the field do not even provide for maintaining such ratio, and the same can be traced to an instructions dated 14/8/2023, whereby such a guideline has been provided. Full stop. He has submitted that even assuming that he has submitted that providing for a particular ratio is only in the interest of public so that maximum participation can be done. Full stop. He has submitted that so far as the present case is concerned, there were admittedly 7 numbers of vacancies, and as per the ratio, 21 persons should have been called for. However, it is on record that as many as 35 persons were called, were found to be eligible for the recruitment process. So he accordingly submits that the requirement of following a fair and transparent method in public recruitment was adhered to, inasmuch as there was wide participation, which was even more than the ratio, and therefore the same would not have been a reason for recommending a re-examination. Full stop. In support of his submission, the Learned Council for the petitioners has relied upon the case of Aravinda Rabha versus State of Assam reported in 2019, 4 GLT 223. Full stop. By referring to the observations made in paragraph 29 of the same judgment, the Learned Council has clarified that in that case, the number of candidates called for was less than the ratio prescribed, and in spite of the same, this court had observed that such non-adherence would not be fatal to the recruitment process. Full stop. He has reiterated that in the present case, the number of candidates is even more than the prescribed ratio, and therefore the same cannot be a reason at all for taking the impugned decision. Sri Panging has informed this court that though the tenure of the appointment was 1 year as per the advertisement, so far as the other is concerned, wherein appointments were made, the incumbents are allowed to continue. And therefore, there is full scope of the department to consider the case of the petitioners for their appointment. Sri Tagum, the learned standing counsel of the department, has, however, defended the impugned action by submitting that the same is not based on any mala fide and is taken on bona fide consideration, as there has been infraction of the instructions dated 14/8/2023. Full stop. He has submitted that the instructions prescribe as noted for maintaining a ratio of 1:3, which was admittedly not done in the present case. Full stop. He has submitted that 21 persons should have been held eligible, as the vacancies were 7 in numbers, and instead 35 persons were held to be eligible to participate. Full stop. He has otherwise not raised any other issue regarding any malpractice in the recruitment process. Full stop. Para. Ms. Wangmo, the learned state counsel, has endorsed the submissions made by the standing counsel of the department. Para. The rival contentions have been considered and the materials placed before this court have been carefully examined. Full stop. Para. The facts which have been elaborately stated above would reveal that so far as the Gyati Taka General Hospital 0 is concerned, there were 7 numbers of posts which were to be filled up. Full stop. Though it appears that there were certain resentments and complaints on the recruitment process, the impugned order dated 27/2/2024 is not based on any malpractice in the recruitment process, but only on the ground that the ratio of 1:3 was not maintained. Full stop.
In fact, my lord, it says, and there is no material of any irregularities at page 93.
This court has also noted that in the impugned order, there is a specific finding that there was no concrete and relevant material of infirmity, correct?
Yes.
Full stop. Para. As correctly pointed out by the learned counsel for the petitioners, the aspect of maintaining a ratio of 1:3 is not a statutory requirement, but is only as per an instructions dated 14/8/2023. Full stop. Without even going to the aspect as to how much enforceable such instructions would be, this court is of the view that the objective of maintaining a ratio is only to ensure wide participation in a recruitment process, so as to maintain a fair and equal opportunity to have the best from the lot. Full stop. In the instant case, it is not in dispute that the infraction of the aspect of ratio is not because of the total number of candidates being less than the prescribed ratio, but of the total number being more than the prescribed ratio. Full stop. By such participation, the objective of prescribing a ratio would not be defeated and would rather would rather be in sync with the said objective. Full stop. As already noted above, the impugned order itself states that there is no other evidence of any infirmity or irregularity. Full stop. Para. In the case of Aravinda Rabha Supra, relied upon by the petitioner, relied upon by the learned counsel for the petitioners, this court has noted that in that case, the infraction of ratio was held to be a mere aberration which should not vitiate the recruitment process. Full stop. It may be mentioned that in the said case, the number of candidates who had participated was less than the prescribed ratio.
Yes.
And even thereafter, the observations as noted above have been made. Full stop. Para. In view of the aforesaid discussion, this court is of the opinion that the impugned order dated 27/2/2025, that the grounds cited in the impugned order dated 27/2/2024 is not sustainable and would not be and cannot be regarded as a ground for recommending a re-examination of the selection process. Full stop. It is needless to state that in a recruitment process, apart from the efforts of the aspiring candidates as well as of the recruitment agency, there is involvement of huge amount of public exchequer, and unless there are compelling reasons, such recruitment process is required to be brought to a logical conclusion and not abandoned or cancelled on trivial grounds. Full stop. Para. In view of the above, this court is of the opinion that a case for interference has been made out, and accordingly, this court and accordingly, the impugned order dated 27/2/2024 is set aside. Full stop.
In respect of Gyati Taka.
Full stop. The present interference, it is needless to state that the present interference is only pertaining to Gyati so and so at 0. Full stop. As regards the practical aspect of offering recruitment to the petitioners is concerned, the department is directed to look into the aspect that similarly situated candidates who were recruited in the same recruitment drive have been extended in their service. And by taking into consideration the aforesaid aspect, the department may take necessary steps. Full stop. Writ petition accordingly stands allowed.
Item 13, my lord, can be taken up some other way. There's an interim order protecting.
1-3, what is the case?
Item number 13.
What is the case?
Same case, my lord. Only reason is that in that case, my lord, skill test was not conducted. That is the only reason.
But skill test is a part of the recruitment rules.
Yes, my lord, that was not completed. So there's a stay order protecting me. So there is no steps being taken.
What do you say, Mr. Rahul?
My lord, that's
Skill test, this
My
cannot be equated with this.
that is right, man. That's why.
Okay, we can have it some other day.
That's right.
Item number 13. On request by Sri D. Panging, learned counsel for the petitioners, more than one petitioner, petitioners. Matter is adjourned to be listed after 2 weeks.
Right.
Sri T. Tagum, learned standing counsel of the department, and Miss Wangmo, learned state counsel are present. Para? Interim order passed earlier to continue till the next date of listing.
Problem.
In the other case, which
I
we
do.
disposed of, there's an IA.
No, there is no IA in the other case.
APL.
Problem.
What is IA 131?
IA 13 was in item number 12, my lord.
Hmm?
Or that may be closed, my lord, in terms of the order passed in the writ petition.
Okay, close, huh? In terms of the final orders passed in the writ petition, no orders are required to be passed in the IA, and accordingly, the same is closed.
Problem.
The previous book, I bring the books and I'll.
Yes, what is it?
My lord, the gateways for the hearings of the admissions. My lord, please see the impim orders.
As I submitted, this is an issue wherein I'll be arguing on the maintainability. That panchayat case.
Yes, 329B and the other
Yes,
67, yes,
yes,
sir, I think.
yes.
67 or 57
Of
of the rules?
That is 243 capital
No, not
O
of the
of the Constitution
not-
vis-a-vis.
Not constitution. Here also is there.
Okay, here there is also section 122 of the Panchayati Raj Act.
Section one.
So, my lord, I'll place the basic facts and then I will argue on the maintainability. That's better. Otherwise, let him answer the question on maintainability before entering into the merit.
No,
Because
my
on
lord,
maintainability, if it is held,
In your favor.
yes,
There is no
then
scope
my
of.
lord, there's no question of entering into the thicket of merits.
my lord, there is so many judgments passed by the Honorable Court regarding of the Panchayat Jila Parishad member issue. Now, regarding the maintainability is a question of the wastage of time of the court also. The way is this Honorable Court has so many judgments is there, my lord, passing of these orders. Now, regarding of the matters of the
No, he is arguing whether a writ petition will be maintainable. He is not saying that you will be left remediless. You can have the remedy in accordance with law.
Yes.
But will a 226 petition be maintainable? That is the question he's trying to raise.
yes, my lord. My lord, please the judgment copies of this JLTs.
What is it? What has been laid down?
My lord, this is Jila Parishad chairpersons.
No, what has been laid down in the judgment?
This is why, my lord.
Yes.
This is the fact of the case is like this.
Mm.
Now, Jila Parishad chairpersons of the Lower Subansiri district, when some elected members of the Jila ZPMs has moved no motion confidence against the Jila Parishad present ZPC, Jila Parishad chairpersons. Accordingly, the matter has moved on the 1/3 of the majorities of the elected member of the Jila Parishad chairpersons. Thereafter, member secretary has properly served the notice to East Jila Parishad members. Accordingly, the no motion committee motion meeting was fixed. So this is as per this rulings, my lord. This is practiced like this.
No, that is challenges to a no confidence. This is a challenge to the election.
My lord, this is actually not elections. This
Your
is
challenge is regarding elections or not?
yeah. Now I am challenging for the notification of the notification issued by the member secretary
For
No.
election, for election,
for the choosing of their Jila Parishad chairperson, my lord. For choosing of their elected within the amount of Jila Parishad members, within the amount of Jila Parishad member after the elections, they have the elected their leaders for choosing of their leader Jila persons.
the case which you are trying to refer is pertaining to a removal.
Not yeah, that is
Removal
this
is
one-
a different aspect.
the
Election is a different aspect.
Yes, yes.
Can you show any matter where election has been challenged and entertained in a writ petition?
Actually, my lord, not the.
No, you said there are many GLTs,
Ah.
many decisions of the High Court.
Hmm.
Can you show any election petition, election matter being entertained by the High Court under two
Yes,
26?
my lord, actually, this is not the election matters. This is the, after the elections, the elected of the Jila Parishad members. Actually, this was during the Lower Subansiri district. In the Lower Subansiri district, the election was conducted,
No, Mr. Tiwari, and both of you have to come to a consensus whether it's an election matter.
not the election matter.
He said it's not
This is
election.
after the elections, after the Panchayat election, elected their, elected of the Jila Parishad members, my lord.
Yes.
Then the respondent members, what was the,
Let us see the provision of the act, how this particular election is to be held.
Better I address my lord, he will be benefited by my argument, he will be able to answer thereafter. Instead of creating this kind of confusion, let me address on maintainability, I'll give you the points. You
no,
answer all
no,
that.
no, my lord, regarding the maintainabilities. Now, learned senior want to be regarding of election process of the Panchayat
Now,
election.
you just show the process, which provision of law, this particular, after the members are elected, let us see what.
Yes, my lord, please, the medal here,
Section,
page 123, page 123.
yes.
Page 123 is section 67, clause 1, my lord.
Hmm.
Now, chairperson of the Gram Panchayat, Answer Committees or Jila Parishad shall be chosen by the elected members of the Gram Panchayat, Answer Committees or Jila Parishad from the amongst themselves in the first meeting of the Gram Panchayat, Answer Committees, Jila Parishad fixed by the Deputy Commissioner, my lord. This was the, my lord, first meeting. First meeting is called by the Deputy Commissioner, my lord, but not by the member secretary, my lord. This is my challenging, my lord. But here's key pioneers, my lord, Jila Parishad, fusion of their leaders.
This choosing of this leader as chairperson
Yes, my lord.
is by way of election or otherwise? How is it?
My lord, this is not the election. They have already elected the leaders. During the elections, the constituency was the elected. After elected, my lord, they have elected their Jila chairperson. Become chairpersons, the all elected representatives to be mandatory for the participated. That is the duty of the Deputy Commissioner for the first call for the meetings, call for all the elected Jila Parishad member, my lord. This is my challenging, my lord. But my lord, in this case, Deputy Commissioner has not called meetings, but meeting was called by your member secretary, my lord, first times. After the first meetings, my lord, after the first meetings, second meetings, the Deputy Commissioner should be appointing to his subordinated officer. That is the member secretary, my lord. But here in case, my lord, Deputy Commissioner has not to call the meetings. Meeting called by the returning officer or member secretary, my lord. My lord, paragraph close C, close to, my lord, close C. Close to, my lord. That meeting shall be held at date and fixed by the Deputy Commissioner at the headquarters of the Gram Panchayat and Answer Committees, Jila Parishad, and shall be presided over by the officer appointed by the Deputy Commissioners, my lord. Here is, my lord, Deputy Commissioners no officer has been appointed for the conduct of elections, my lord. This is my challenging is that, but notification is the issue by the, my lord, member secretary is returning officials without any knowledge of that Deputy Commissioner, my lord. Key pioneer is, my lord, recently district created, bifurcated from the Lower Subansiri district, my lord.
No, but Mr. Bhui.
Yes,
let us let us concentrate specifically on the point, which is the issue taken up by Mr. Tiwari in his maintainability. First, you see the provision of 67(1).
Yes, my lord.
The chairperson of a Gram Panchayat, Anchal Panchayat Samiti or Zilla Parishad shall be chosen by the elected members of the Gram Panchayat, so and so, from amongst themselves in the first meeting of so and so. Though the heading is election of chairperson, the expression of election is not in the statute, in the substantive part. It is called chosen. And immediately if you come over to turn to 69 regarding election disputes.
Yes, my lord.
Election dispute, please read. The petition referred to as clause A1 of subsection 3 of section 122 shall be filed before election tribunal within 30 days. Okay?
Yes,
Now,
my lord.
if you come to 122, 122.3, come to section 122. Of the Panchayat Raj Act, Arunachal Pradesh Panchayat Raj Act 1997. Have you got 122?
122, like this. Yes, my lord.
This is 120.
122, have you got? Come to subsection 3. 3.
Three, my lord.
Please read. Please
Uh,
read.
The government will be constitute the election tribunals consist of the one members to be appointed as the government to dispose.
What to dispose? Number A1. All
A1,
election
election
petitions
petition shall challenge election to the
challenging
panchayat.
elections to a panchayat.
Panchayat, my lord. The matter related to the disqualification,
This we are not concerned. We are concerned with only one.
one,
All election petitions challenging elections to a panchayat.
panchayat.
Now, whether this appointment of the chairperson would be construed to be an election of the panchayat. If it is an election of the panchayat, then this 122 will come into operation because it starts with a non-obstante clause.
Yes.
It starts with notwithstanding anything. And in accordance with subsection 3, an election tribunal would be constituted and the tribunal will decide these matters, 1, 2, 3, 4. So if Mr. Tiwari is able to demonstrate that this particular choosing would also come within the definition of election, then perhaps there will be an issue of maintenance which we may have to answer in favor of the respondent.
Yes.
But if you can make out a case that it is not election, the elected members only chooses the chairperson.
Yes, ma'am.
There is no election, then maybe a writ petition may be maintainable.
Yes, yes. Sir. Yes,
Have you understood?
yes, understood.
So we have to revolve the entire discussion and deliberations will revolve around all election petitions challenging election to a panchayat. Elections to a panchayat. What is the meaning of elections to a panchayat? Whether the chairperson of a Gram Panchayat, so and so, shall be chosen. This word chosen will come within the definition of election. How is he chosen?
My lord, regarding of this elections of this become filing of before the election tribunals.
Section?
Election tribunals. That in case of during the general election of the panchayat, entire of the district or village level, district levels, if any dispute, like examples of, in case of the, my lord, in case of the rejection of the nomination papers, in case of the some improperly voting at the time of voting times, or that may be filing before this. After that, my lord, elections, elected members of the Gram chairperson, Anchal Samiti chairpersons, is elected member of the duty to be choose their leader from their political parties, among their political party, my lord. This is a political party is a mandatory, my lord, in the panchayat in Arunachal Pradesh. Now, respondents, force and other Jila Parishad member have been elected as from the BJP party initially. At the time of Lower Subansiri district, their elected Jila Parishad member has been from the party ticket, whom the party has been allotted to the ticket, he has become elected as majority of the party. Well, this is not likely, my lord, as elections of the like this. Now, here in Konjan case, my lord, here is in Lower Subansiri district, in earlier, the one district was there. And that times, total members of that BJP was winning the case, majority party.
The party thing, we are only on the aspect of whether you come to the chair by means of an election and the word choosing,
Yeah.
will it also be incorporated in the broad term of election?
Yes, yes, yes.
If it is election matter, our decision may be different. If it is not election, decision may be different.
Yes. My lord, here is only for the duty of the deputy commissioner for the call meeting for the all elected Jila Parishad members for the whom you going to choose your chairpersons. This is only must that. It's duty of the deputy commissioner for the call meetings. But my challenge is that, my lord, here was deputy commissioner was not the call meetings, but call the meeting by the member secretary only. That is my challenging was that. Election, there is no any dispute.
No, we are not on the merits. You may have different grounds of challenge, whether it's deputy commissioner calling or the member secretary. These may be grounds. We are not on the merits of your dispute, which you are raising. We are only on the aspect whether writ petition will be maintainable to go into the dispute or whether it should be relegated to an election tribunal, which Mr. Tiwari is harping upon,
Yes.
that it's a matter pertaining to concerning elections, and there is a tribunal constituted under the law, and there is no scope of this writ petition.
Now, my lord, that is why, that is my case. So I challenging that notification issued by the member secretaries without any proper serve the notice, without the proper serve the notice to all elected members. Like I'm a Jila Parishad member of the BJP party. I was not to give opportunities. As per that, accordingly, I was representations submitted before the learned deputy commissioners for the very short notice. Within the short period, also some holiday was there, national holidays of that times.
Mr. Tapin, at this point,
Lordship, as
we want to
what
be
I'm-
addressed this.
what I'm-
Mr. Bui is not addressing this point. He is going on merits.
What Lordship I'm observing is that Lordship. Now, on this particular issue, Lordship, with the elections of the chairperson,
Yes,
it will come under the election dispute only.
yes, yes.
When I see the Lordship definitions for election in this particular act, Lordship, it says Lordship, it doesn't talk about the elections of chairperson.
Chairperson.
Therefore, what I'm suggesting is, Lordship, I may be allowed to Lordship file affidavit on this particular point. This honorable court may direct me by order to say on this particular point, Lordship, because it's going to have some consequences, Lordship, for the future.
You're correct, you're correct. But see, there are also aspects of use of ballot papers, Mr. Tiwari. Here, so the aspect of election may come in, but the very purpose of having a tribunal is because these are factual disputes of factual in nature, which we may not be in a position even to make a decision.
Without
So,
taking evidence.
yes, the question of evidence will come. That is why tribunal is there.
Yeah.
So, but here, if it comes, the use of ballots is also there. You kindly come to, we'll definitely consider your thing. You come to 67. '67 is pertaining to the choosing. Let us use the word expression choosing. Choosing the election person as So as given in the statute, but if you come
Sub
down,
Rule 4, 7, 8,
yes,
9.
yes. You come to 9, the ballot paper for the election shall be in Form 28. But at the same time, mere use of the ballot paper, will it constitute, can it be constituted to be an election within the meaning of this? You file an affidavit, I think best. Is that worry? I think.
Either way, my lord, I have
Because,
applied, my lord knows.
Because what I was.
This is an issue, my lord, I have applied my mind, and that's why in
No,
all
we were expecting
seriousness.
Mr. Bui to assist, but he
That
was
is
on
why,
a
my
different.
lord, in all seriousness, I'm advancing this argument.
He is on a different footing. He is on the merits. We are not saying anything on the merits because we have not even entered into the arena.
Because, my lord, I have applied my mind, in all seriousness, I'm advancing this argument because I have noticed, unfortunately, there is a prevailing feeling among the members of the bar that any indirect election cannot be treated to be election. So, but this is an issue which needs a very serious consideration. Law will be settled.
But the use of the expression chosen, they have not said elected.
Only once, my lord, the word chosen has been used. Later on, election also comes.
But you tell us one thing.
My lord, in the rule itself, my lord will find the word elected thereafter.
Mr. Tiwari, how many members would be choosing a chairperson? Only 10.
My lord, in this case,
Only
six,
10.
my lord, in this case, 6 are there.
The
Right now, only 6 are there.
Maximum 10.
My lord, but election is an election, be it 6 or 6,000. Ultimately, the significance of election, be it 6 or 6,000, the concept remains the same.
No, and there is one more aspect. He is not alleging any irregularity in the voting process. He is on the route.
Mohinder Singh Gill says, my lord, Mohinder Singh Gill says,
Public order.
my lord, the expression used is, in fact, the sentence is in the Mohinder Singh Gill, in a situation wherein the order of the High Court has the effect of preventing the election, then interference is not permissible.
Yes.
High Court can only
let's say,
interfere.
If it is in sync with this, then it should not be. Otherwise, only if it defeats it.
Yes.
Yesterday you have.
Because a High Court, the Mohinder Singh Gill says, High Court can pass an order under
the 78 decision, the same decision. Where
Mohinder Singh Gill has been referred to.
No, there are two Mohinder Singh.
My lord, the famous Krishna Iyer. The famous
where
Krishna Iyer.
Gordhandas has been.
Yes.
78. This is
78 Supreme Court.
378.
But the Chief Election Commissioner.
Yes.
And my lord, that Mohinder Singh Gill, subsequently referred to by Supreme Court and series of other cases, and then in the matter relating to Panchayat also, Mohinder Singh Gill has been referred. Supreme Court is unanimous about the view that Article 329 is perimeteria to 243 capital O. And the Panchayat has been treated to be the genus of the different facets of Panchayat. And election can be both indirect as well as direct. It can't be that only in the matter of direct election.
Are you contending that indirect elections
yeah.
are also to be considered?
In this case, yes. And I will demonstrate, my lord. I have looked into this aspect. It will be a very interesting proposition.
Okay. Third, 3.
But my lord, then I'll have a problem. My lord, I'll have to leave this evening.
No, not tomorrow. No, he is.
Oh, very well.
He's filing an affidavit.
Very well. My lord, then it will go to June, my lord. Preferably.
Date is not a problem. Let us first. Third, 3P Bui, Learned Counsel for the petitioner. Also heard 3S Tapin, Learned Senior Government Advocate AP. Whereas on the Azina Ping, okay, you first write his name, huh? What is your name? Learned Counsel appearing on instruction of E. Apang, Senior Counsel representing the Election Commission, State Election Commission. 3 S Tapin, Learned Senior Government Advocate, Arunachal Pradesh. Footstep 3 PK Tiwari, Learned Senior Counsel assisted by, yes, your name? Please write. He is present for the private respondent. Full stop. 3 Tiwari, the London Senior Counsel, has raised a preliminary issue questioning the maintainability of the writ petition by contending that the dispute has to be raised before the duly constituted election tribunal and not by way of a petition under Article 226 of the Constitution of India. He has submitted that the Act and the rules holding the field has provided for such remedy, and the Constitution itself lays down a bar for any other court to adjudicate matters pertaining to election. Purstapkara. Sri Bui the learned, Sri Bui the learned counsel for the petitioner has, however, submitted that the present petition is maintainable. Purstap. A perusal of section 67 Rule 67 of the Arunachal Pradesh Panchayat Raj within bracket conduct of election bracket close rules 2001 would no, don't select it. Don't select it. Part 6 of the so-and-so rules of 2001 pertains to election of chairperson of Gram Panchayat or Anchal Samiti or Jila Parishad. Full stop. Rule 67, which comes under the said part, provides that the chairperson, such chairperson, shall be chosen by the elected members of the Gram Panchayat, Anchal Samiti or Jila Parishad from amongst themselves in the first meeting of the Gram Panchayat, Anchal Samiti or Jila Parishad fixed by the Deputy Commissioner. Full stop. Though the expression within inverted comma chosen has been used in this Rule 67 within bracket 1, the other sub rules would also reflect that such choosing may also be construed to be an election, as there would be use of ballot paper, which is evident from 67 within bracket, from Rule 67 within bracket 9. Para?
Also 7, 8, 9. Allotment of symbols.
There is also provision for assigning of symbols and of having a secret ballot. Full stop. Para. At this stage, Sri Tapin, the learned State Council has submitted that since the issue raised would have ramification in other matters, the stand of the state is required to be put on record by way of an affidavit. Full stop. This court is of the view that before taking a decision in this regard, the stand of the state may be necessary, which would also be considered. Full stop. Para. In view of the above, the matter is adjourned by 3 weeks.
This whole is because opinion of the law department.
4 weeks, 4 weeks to enable the state to file such an affidavit. Full stop. Please, shall we give a date?
Let them file the affidavit, my lord, thereafter, once we get a
4
copy.
weeks, 4 weeks. Interesting point.
Yes, my lord, in fact, both Maxwell as well as the GP Singh interpretation of a statute, there is a proposition that the word used in the heading of a chapter may determine the nature and the color of the word used within the provisions.
Substantive part of the statute.
Yes, may in a given situation.
Even
So that is
even
why-
there are reference about side notes, footnotes,
Oh, yes,
everything.
yes, yes, yes. So that's why
The sit-
merely because the 67(1) uses the expression chosen would not necessarily mean that it is.
No, we have just
Yeah,
indicated.
that's why my lord has indicated. that.
Indicated.
Fair enough. Interesting, very interesting. That's why my lord I looked into it and I.
Yeah, Your Lordship.
Yes.
On the last occasion, Your Lordship, this court has directed the registry to ascertain the whether service upon the respondent number 8 has been completed or not. But Your Lordship, on 1/08/23, they have appeared and submitted that they will rely upon the affidavit filed by the respondent number 6. So all the respondent has filed their affidavit, your counter affidavit. The private respondent had submitted they will rely upon the affidavit
Yes.
filed.
So what do you want?
For admission hearing. Your Lordship.
Okay. When this matter was taken up for consideration on the last occasion, that is 21/10/2024, it was a submission made by the learned counsel for the respondent was recorded regarding grant of time to file counter affidavit. Full stop. Miss, your name?
Pirimi.
Miss so-and-so learned counsel for the petitioner has, however, referred to the order dated 1/8/2023, in which the submission of the said counsel appearing for the respondent number 8 was recorded that no counter affidavit is required to be filed by him, and he would rely upon the stand taken by the respondent number 3 in the counter affidavit. Full stop. Clara? She accordingly submits that the matter be listed for admission hearing. Full stop. 3. So-and-so London State Council is present. Full stop. However, there is no representation on behalf of the respondent number 8. Para? In view of the above, list this case for admission hearing after a week.
God bless you.
(16 and 17).
My Lord, sir. My Lord, I beg to withdraw my IA. This is with respect to impediment of the applicant as respondent number 5.
You don't want to be included?
No, I'm not required in the case anymore.
You have been threatened by the other side.
No, my lord, sir.
Not threatened.
I've got a petition, my lord.
Then you have been requested.
My lord, there has been some subsequent development, my lord, and
First, let us dispose of his IA.
yes, ma'am.
IA number 196.
196.
What is your name?
W. Khomrang.
W.
Khomrang.
Khomrang.
Yes, ma'am.
Pre W. Khomrang, learned counsel for the applicant, has submitted that though this application was filed with a prayer for impleading the applicant as respondent in the connected writ petition, comma, he has instructions not to press the same. Full stop. 3. B. Picha, learned counsel for the opposite party writ petitioner, as well as 3. So-and-so learned state counsel do not have objections to the aforesaid prayer. Para? I accordingly stands disposed of as not pressed. And don't say disposed, dismissed as not pressed, dismissed. Yes, what about writ petition?
My lord, there is one development, my lord. Actually, I have challenged the authority of the ADC, Additional Deputy Commissioner, to take cognizance of the complaint filed by one private respondent, my lord. Now, taking cognizance of the complaint, my lord, this Additional Deputy Commissioner has constituted a kebab. Now, he could have forwarded, my lord, but he could not have taken cognizance of the matter, my lord. And my lord,
You filed an IA.
my lord, what happened, my lord? This is one, my lord, this is one subsequent development, my lord. Order passed by the additional deputy commissioner, my lord. So, my lord,
19 November.
yes, my lord.
Now you file an IA,
My
will.
lord, if my lord, they can take instruction, I have served the copy, my lord. If they
Yes,
can take the instruction, we can close the matter.
In the writ petition, Sri B. Picha, learned counsel for the writ petitioner, has submitted that there are subsequent development during the pendency
Yes.
of the writ petition, full stop. He has placed before this court copy of an order dated 19/11/2024 issued by the ADC, whereby the KBAM, which was formed on 13/9/2024, was cancelled.
Yes, ma'am.
Full stop. He submits that in view of the aforesaid order, there may not be any requirement to pursue the writ petition. We can close it, I think. Mr. Ivan,
Yes, Your Lordship.
we can close this.
Your Lordship, but I have to seek instead whether the
No,
genuinity of
this,
this.
we should,
Because
you
officially,
get telephonic instruction, we'll close it tomorrow.
Yes, yes, ma'am.
yes, Your Lordship.
Sri so London State Council press for some time to obtain instructions on the aspect of issuance of this order dated 19/11/2024. For Satara. In view of the aforesaid request, the matter is adjourned to be listed tomorrow. By which time the London State Council will have telephonic instructions.
Yes, Your Lordship.
That is the view. No point having
ma'am.
this pending. We'll have closed this.
Yes, ma'am.
Obliged.
You have given copy to him.
Yes, I have done it.
Yes, I have the copy.
IA 262, my lord, is an application for impleadment, my lord.
Item number
18.
262 is for impleadment.
Yes.
You want yourself to be impleaded
Yes, madam.
in writ petition.
In the writ petition.
Whose writ, your writ petition,
Yes.
madam?
We have no objection, Your Lordship.
Impleaded as per number.
Yes, 3 to 10.
Who are you?
My lord, we were appointed the direct recruits on
You would be
the year
affected, you would be
2012.
affected, you may be affected.
Yeah, I
by
will be
the-
affected.
Okay, and yes. Okay.
Oh, acha.
And you are for petitioner, along with madam.
He is in another matter.
But your petition is on the application is only
Yeah.
for this 262, which one?
262, my
In-
learned
in
friend,
14, in 14,
CAP,
14.
Yes,
WP 14.
14.
Okay.
There's another implement application.
First, let us dispose.
Yes,
of
madam, that's right.
262, okay? Third, 3D Panging. Learned counsel for the applicants who by means of this application have prayed for their impleadment as respondents in WPC 14 AP of 2022. Full stop. It is submitted that the subject matter of the writ petition pertains to a selection, pertains to a recruitment process,
No, my lord, they are claiming retrospective promotion.
pertains to a claim for retrospective promotion in which the present applicants would be affected. Full stop. Miss, Madam, your name?
K. Chotan.
Miss so learned counsel for the opposite party writ petitioner. One writ petitioner, how many? Writ petitioners? As well as Sri S. Tapin, learned state counsel, senior government advocate, do not have objection to the present full stop para. In view of the above and considering that any decision, notice, taken in this writ petition may affect the rights of the applicants, the applicants are The prayer for implement is allowed, full stop. Accordingly, the applicants are arrayed as respond numbers
3 to 10.
3 to 10 in WPC, so and so, full stop. I accordingly stands allowed. The learned counsel for the opposite party writ petitioner is directed to file an amended post title, which is to be done within a week from today.
Yes, sir.
In item number 20, my lord.
The entire petition need not be amended, madam, only the cost title.
Right. Yes, sir.
Having the names, yes.
Item 20, I number is 263 in WPC 459. Same order, my lord. Same prayer.
Same.
Retrospective promotion. 3 to
Yes.
10.
You're there, or who's there?
His,
Your name, give your name.
on behalf of our circuit. He has said no objection.
Oh, yeah, and so and so on behalf of our sake, yeah. And WPC is, and process is the same.
Same.
Retrospective.
Yes.
Huh? Same order, no? Disposed of. And you have to file amended cost title within a week, okay?
I will inform. Item 21, my lord, we are implemented here already, so we have filed our affidavit also.
21, no order is required.
No orders.
21, you write, list along with WPC so and so.
In these two writ petitions, we will file affidavit, ma'am.
And then in each of the IA, do disposed of, you write, the newly implemented respondents, the applicants who have been newly implemented may file their affidavit in opposition within
4 weeks.
within 3 weeks.
My lord, I'm appearing for respondent number 2 to 5.
Where
this
in
matter,
which case?
item 21.
21. First case,
No, last case.
Last-
My lord is passing order in my lord 18 and 20 now.
21, 21. you
21,
write,
no,
21, just list,
Yeah.
give the appearance, okay? Madam, you are appearing for 21. Writ petitioner?
yes, for the petition.
Yes, sir.
Madam for writ petitioner. As Tapin for,
5.
as Tapin for, respond number 1,
1 and 2.
1 and 2, 1 and 2, and you are for?
2 to 5.
He is also for 2.
Only one. Only one.
Tapin for 1, 2 to 5 his name, and 3 to 10.
6.
I'm sorry, just a moment. ma'am. 6 to 13.
6 to 13 by Deepangin, huh? Then list along with 18 and 19. WPC.
Obliged.
समझ गया ना? First two would be orders, third में there is no orders, only 5 pass an order in the writ petition, recording the names of the council and listing allowed. And in both the IA which have been disposed of, you have to write, so and so, newly implemented, shall file affidavit within 3 weeks. So,
Obliged.
22. 22, Mr. Picha.
On the last occasion, my lord, this honorable court has directed the respondent number 4 to post service of notice upon the respondent number 28. Because we are not in address with the respondent number 28. We do not have
Your
any.
Lordship, I have forwarded the letter to the respondent number 4, Your Lordship, but the compliance letter or report I have not received yet. I need some time, Your Lordship.
You have sent it to.
Yes. To the Director General of Police. Respondent number 4.
Peruse the office note dated 25/2025 regarding service report in respect of respondent number 28, which is to be received through the Director General of Police, Itanagar. Full stop. Para. On the prayer of Ms. Basar, the Learned State Council, further time of 2 weeks.
Lordship, 3 weeks may be granted because on behalf of respondent number 3 also I have to file affidavit, Your Lordship.
No, regarding this
Notice.
report.
Notice,
okay,
yes, notice to.
What did they write? Matter is adjourned by 2 weeks to enable her to obtain instructions in that regard.
Lordship.
Public.
Problem.
My lord, these are those matters, my lord, will report where the IA numbers got mixed up and my lord. My lord, will take up IA 117, my lord.
117.
117. I supplied a copy of the order earlier, and supplying again, my lord. But it already passed order on the last.
What are these matters?
My lord, the reservation on the basis of my lord domicile, my lord. So, my lord, during the pendency of the writ petition, we have challenged the notification by which this reservation has been put in place as page 14.
Hmm.
In the meantime, this advertisement at page 21 has been issued.
Hmm.
Page 14 is the notification that we are putting to challenge. That person post out of 80% reserved in group C and multi post born in all
Now,
departments.
what is the order you would like us to pass? What is the?
My lord, similar order you also had passed earlier,
Yes,
that
what you
not to declare the make appointments with the leave of this court. Apparently, my lord, the advertisement is going unconstitutional.
Okay, yes.
On the face of the order, Lordship.
Third, Sri D. Pangi, learned counsel for the applicants. One or more than
one applicant.
applicant who by means of this petition has prayed for an interim order protecting his rights. Full stop. The said interim order has been prayed in connection with an advertisement number APSSB -13/5/2025/2024 dated 11/4/2025, whereby online applications have been invited for combined graduate level examination CGLE capital 2025 from eligible candidates. Full stop. The grounds of challenge is on the aspect of domicile. Full stop. Without going deep into the merits, the learned counsel has submitted that in a similar matter, this court had passed an order protecting the rights of the parties. Full stop. He has placed before this court an order dated, copy of the order dated 7/9/2022, passed by this court in WPC 27/2022. Full stop. Para. Sri Astapin, learned senior advocate.
In this case, in IA Lordship, my friend will be appearing for the state Lordship. I am APSSB Lordship, staff selection recruiting authority. In this IA, I have not been implicated as a party yet. But in main case, I am the. I have.
Miss, one more learned state council is present. Any of four? Who's this one number 4?
Union of
Union of
India.
India.
On
This
behalf of
resolution
Takato?
can be made by only by the union, subject to court.
Okay, appearing on instruction of Sri M. Kato, learned deputy at GI. Both the learned council, however, has not raised serious objection in view of the earlier order dated 7/9/2022 mentioned, referred above. Better? Considering the facts and circumstances, and also after perusal of the order dated 7/9/2022, passed in a writ petition concerning an analogous situation, it is provided that while the recruitment process as per the advertisement may proceed, comma, no appointments are to be made on the basis of the aforesaid recruitment without taking the leave of the court. Full stop. The aforesaid restraint is only with regard to
Postcode number 06/25.
postcode number
06/25.
06/25/25.
/25. Okay.
I can dispose of.
Problem.
Lordship, I'm appearing on behalf of M. Khatam. Lordship, in this matter, the impugned judgment and order dated 29/10/2024 has been stayed.
Stayed by an appellate court.
Sorry?
By an appellate court or what?
Yes, yes, Lordship.
You had preferred a writ appeal.
Yes,
The impugned judgment has been stayed.
yes.
Okay.
Sir.
What do you say?
Your Lordship, actually, I'm not the counsel for this. I've been assigned to ask for adjournment.
On behalf of whom?
Iraq Ban.
Iraq Bam. Okay, you please. Sri so-and-so, your name, huh? Please.
M. Taso.
Learned Counsel appearing on instruction of Sri I Bam. No, Sri so-and-so has paid for an adjournment on behalf of Sri I Bam, Learned Counsel for the petitioner. Para, Miss so-and-so, Learned Counsel appearing on instruction of Sri M. Katu, Deputy SGI, has however
Lordship, not the SGI. It's a private matter, not the SGI.
as, oh, okay. Appearing on instruction of Sri M. Katu, Learned Counsel has however informed that the judgment and order in question has been stayed
Yes, Lordship.
by the division bench in WA number
8 of 2025.
8 AP.
Yes, Lordship.
WA 8 AP of 2025. Fourth para. Be it as it may, and as requested, the matter is adjourned by 2 weeks.
Okay.
Do you have the copy?
Yes, Lordship.
Make it ready next time. Okay, next. Are you for?
I for extensions of time frame, Lordship, to comply the order of dishonorable court. Lordship. 3 months time was given by dishonorable court to assess and to pass the award, Lordship. This is pertaining to land compensation matter.
Okay.
I'm
Now,
asking for, Lordship, 1 month for the time, Lordship.
a month, sir. Yes.
My lord,
3 months is over, I think.
It's over, Lordship.
When was it over?
Lordship, actually, the certified copy was received on 24th, Lordship. But copy was served by them, Lordship.
it's
Official, they were waiting for.
receive is acknowledged, my lord.
What do you say? 1 more month?
My lord, I have strong objection to this, my lord. Lordship, kindly see the timeline.
No, he talks about 1 month, but as per my information, practically the things are over. It may be within days he may get the money. But though, to be on safer side, he's asking
You're
for that
for
time.
whom?
I am for NHPC because I have been told work is all done. Since the state has to do certain formalities, that is why possibly they are seeking some time, but it may not take even 1 month. It may matter of days, as I understand. Everything has been done.
It sounds good, my lord.
Mr. Abha is not even appreciating that the period of waiting is much better than after receiving.
He should,
My lord, the fake remains, my lord.
they are getting it. I know
They-
it has been approved.
The applicant has
Here
come
you
with
can
this,
have
I am, my
all
lord.
expectations open.
On-
Once you receive it, nothing, everything will end.
The
He
IA,
will be out of the picture. He should know that.
Have you read Yero Unvisited?
my lord.
You must have read. You're a person of literature. Yero Unvisited. Have you read?
Sorry, I have not read, my lord.
It's
Yes,
Yero unvisited. And read Yero
Roads
visited.
unvisited, my lord.
Huh?
Roads unvisited.
No, Yero. Yero unvisited.
My lord,
This period is best, that something is coming. Once it comes, everything will end.
That's it.
my lord, in this particular case,
1 month, 1 more month you can enjoy.
kindly see the timeline, my lord, of filing this IA, my lord. Immediately after receipt of the contempt notice, my lord, on
So you have
16th.
filed contempt.
Yes, my lord. Just to, my lord, circumvent the contempt proceeding, my lord. Kindly note the timeline, my lord. 16, the date on which the contemptor has received the, lordship, the notice. Then they have come with this interlocutory application, my lord.
Lordship, that's not the intention behind the filing of this application. Why, Lordship? In contempt itself, the notice has been issued for 4 weeks, Lordship.
It's
Written only after 4 weeks, Lordship. By then, this 1 month will be expired,
So at
Lordship.
the time without the contempt comes after notice.
So therefore, there's not
Therefore, my lord, it is,
Contempt also they won't succeed. I can demonstrate.
it is absolutely unwarranted, my lord.
In contempt also, I will appear again. I'll take time to file objection. Then it will go for.
Now,
other
respondent number
things
3 has
also.
come. Tomorrow, my lord.
So just to say, Lordship, the intention is not the Lordship contempt.
Heard Sri S. Kapil, Learned Counsel for the applicant. Also heard Sri S. R. Rabha, Learned Counsel for the opposite party petitioners. Full stop. By this application, the application, a prayer has been made for extension of time to comply with the judgment and order dated 10/2/2025, passed in so and so. There are 3 writ petitions. 2 or 3. Full stop. It is submitted that compliance of the order involves assessing and paying the compensation. And in this regard, steps have been taken in the right earnest. And even thereafter, the matter could not be completed within the time frame, and therefore, extension of time is paid for. The aforesaid prayer is, however, strenuously opposed by Sri Rabha, Learned Counsel for the opposite parties, by submitting that the present move is nothing but to circumvent the contempt petition, contempt proceeding which has in the meantime been initiated by the petitioner by filing contempt petition. Full stop. Petitioners, full stop. Not para. He has also submitted that sufficient time was granted by this court of 3 months, and therefore the present prayer does not appear to be justified. After considering the rival submissions and also the subject matter involved, this court is of the opinion that the present prayer may not be held to be unreasonable. Full stop. However, this court is not inclined to grant a month's time from today, as in the meantime, more than 3 months has already elapsed. Full stop. Accordingly, extension of time for compliance is granted till 11th of June.
11th of June.
11th of June. By 3 weeks. By 3 weeks.
Could be 2 weeks, my lord.
By 3 weeks.
Mr. My senior friend has already submitted, my lord. All are ready, my lord.
No, by 3 weeks. By 3 weeks. Full stop. Full stop. इससे पहले कहा after Rabha, Sri Tapin, the Learned Counsel has, however, refuted the allegation that the present application has been filed only to circumvent the contempt petition, and has submitted that the petition has been presented bona fide. Relevant. IS can dispose of.
Online.
My lord, in the main writ petition, NSPC has already filed its affidavit in June, my lord, 2024. Sorry, on 20, no, yes, June 2024, we filed our affidavit in the main writ petition. Now they have filed an IA. Today itself, we got the copy, my lord. We would like to file our response, but point
IA
is
for,
noted.
Mr. Soon, IA for?
My lord, for this application under section 27 of the General Clauses Act, man.
Regarding?
Regarding, my lord, completion of the by postal service.
Regarding whom, service to whom?
To my lord, number 4 and 5.
Who are 4 and 5?
Oh, now I understand. My lord, actually, it seems I was instructed, in fact. On the last occasion, Mr. Saxena had appeared. Since, my lord, they had made the general manager NHPC a party. Justice Surana was of the view that MD, right?
Yes.
MD ought to have been made a party and not general
No,
manager.
Chairman.
Otherwise, affidavit we have filed.
The corporation is there, I think.
Yes. Sometimes.
No. Is the corporation there or not?
Corporation is very much there. Sometimes, my lord. Anyway, I should not say anything.
That is okay. That is okay.
Affidavit.
No, we would have taken a very serious objection or exception if the corporation as such, the entity was not there. If the entity is there, who's representing?
Affidavit will not change.
Yes,
Affidavit would remain the same. Whether MD or whether
you can appear. I think you can appear on behalf of 3 and 4.
Yes, my lord, I will.
He will
In any
appear.
case.
Mr. Saxena is reluctant to receive the copy.
Fine, my lord, fine.
2024. Saxena, Mr. Saxena is reluctant to receive the copy.
Reluctant to receive
Yes.
the copy.
You have given a copy today?
Yes, already, sir.
No, we'll allow this IA.
Yeah, my lord.
Why?
Oh, yes, IA should be. I have no
IA.
difficulty. But I believe in IA there is a prayer for survey also. Am I?
Yes.
That is the problem, my lord, because that is
Let us
made
see
in
the
the main
prayer.
petition.
Please to consider. Okay. We'll make some observation. So far as the survey part is concerned, we'd like to have your thing on record.
My lord, I'm objecting to it because that is the main prayer in the
No,
petition.
we'll have your objection on record. We are not passing any orders on the second part. Third, 3, T soon. We remember your name. The other day we were confused. We have come after a long time.
Amongst the very, very senior member
most.
of the bar,
Yes,
very, very senior.
Heard Sweetie Soon, learned counsel for the applicant who, by means of this application, has made the following prayer. Prayer quote kar dena. We're at page 16. He has submitted that by invoking section 27 of the General Clauses Act, service upon the respond numbers
4 and 5.
4 and 5 should be deemed to be complete. He has also submitted that such an application, such a prayer is required, as on the last occasion, the learned counsel appearing for the corporation had declined to accept notice on behalf of the aforesaid respondent. Full stop. This petition, as would reflect from the prayer quoted above, also contain another aspect regarding resurvey, re-verification of the areas of the land. Full stop. Para. Sri P.K. Tiwari, learned senior counsel, appearing on behalf of the corporation, assisted by R.L. Tungon, has submitted that no orders are required to be passed so far as the first part of the prayer is concerned, as he would appear on behalf of the said respondent numbers 4 and 5.
Five.
5.
5.
5, Mr. Kato.
4 is Union of India.
Only five, huh? Not five. Madam, you're for anybody? Okay, we'll record your. Sir, lawyer for state, okay. However, so far as the prayer regarding resurvey, etc. is concerned, he would like to file, he has serious objections and would file affidavit in this regard. Also heard Sri Loya, the learned state counsel. And Miss, Madam, your name? You raise your voice, Madam. Learned counsel appearing on behalf of Sri M. Kato, learned deputy AGI. Put the para. In view of the above, come on. The aspect of service upon the respondent of 5 is deemed to be complete. Full stop. On request of Sri Tiwari, the learned senior counsel, 3 weeks' time is granted to file objection to the other aspect of the IA.
Much obliged.
May I sign balance?
Yes.
But here I was supposed to.
You are trying to scare the court by the size of your brief. Brief?
No, no, my lord.
How many pages?
Well,
500 pages.
yes, my lord.
Yes.
Now, my lord, in this case, my lord, I was supposed to take.
You don't need to go to the gym. If you carry daily to the court.
Here, my lord, there is as much as my lord 726 private respondent, my lord. So, last occasion I was directed to take step, my lord. There's some.
You take steps by paper publication.
Yes, my lord. I'm praying for that.
You will do it.
I'll do it, my lord. I'll kindly allow me to paper.
Yes, madam.
You have to serve extra copies to us also.
He has not served. How can he serve 500 pages?
I will serve, my lord.
Okay. But was the notice, initial notice, how did you take steps?
No, not, could not, my lord, that time, my lord, my humble prayer, my lord, it cost me around 12 lakhs, my lord, so that.
12 lakhs?
That will, my lord, to register post, my lord. So that cannot be managed a petition, well, so I'll praying for my lord. Paper
Why
public.
have you accepted the brief? To suffer loss. 12 lakhs for steps.
I tried to calculate that, my lord, it even goes up to 12 lakhs.
You should have negotiated the postal department. Making a bulk booking, so discount.
So I humbly pray for my lord.
Okay, heard Sri L. Perme, learned counsel for the petitioners or what?
Petitioner, my lord.
Petitioners. As well as Miss Wangmu, State Council, full stop, para. Do notice was issued in this writ petition on
10, my lord, 10/4.
10/4/2025 and there was a direction for taking steps for service of notice by registered post with AD. The learned counsel has submitted that taking into account the number of private respondents who are read from respondent number 6, Tier 2, respondent number 710, the notice may be allowed to be served by paper publication. He has submitted that serving of notice by registered post with AD of this petition is practically not feasible, as it would incur a huge expenditure which cannot be borne by the petitioners. Full stop. Tara. Ms. Wangmo, the London State Council has however complained that even extra copies have not been served upon her. Full stop. Tara. Sri Parme, the London Council for the petitioners is directed to serve extra copies of the writ petition to the London State Council within a week from today. Further, his prayer for allowing the petitioners to serve notice on the private respondent numbers 62710 by paper publication is allowed as an exceptional case, as the writ petition with annexures consists of how many pages?
513 pages.
500, more than 500 pages. Full stop. The paper publications are to be made.
Within
Which paper? Which paper? They belong to which
Kurumkumi, my lord. The appropriate Arunachal Times, my lord. This is circulate to whole state, my lord. And my lord, to Arunachal and Times and others, my lord.
And Assam Tribune.
Assam Tribune is not circulate area, my lord.
Dibrugarh Addiction, no. Then what paper? Tell us.
Eco, my lord. Eco. Arunachal Times and Eco, my lord.
Eco?
Eco of Arunachal, my lord.
Please give the names. Such notices are to be published in one edition of the Arunachal Times and another edition of
Eco of Arunachal.
Eco of Arunachal, which have wide have wide circulation in the area concerned. Full stop. The said paper publications are to be made within 4 weeks.
Within 2 weeks, my lord, I will do it.
Within 4 weeks from today, and the notice has to be vetted by the registry of this court, wherein the next date is to be clearly reflected. Full stop. Let the next date be fixed on 4 weeks, after 4 weeks. Today is 1, 2, 3, on 18th of June. Full stop. Before the next date fixed, the Learned Counsel for the petitioners is required to file an affidavit to bring on record the aforesaid paper publications. Full stop. The Learned Counsel has also undertaken to serve the copy of the writ petition along with all enclosures to the respondents on their appearance.
High level.
12 lakh reduced to how much?
Pardon, my lord.
12 lakh will be reduced to how much?
Around 3 lakhs, my lord. I believe, my lord. 3 or
3
2
lakhs?
2 lakhs.
Why? Paper publication is not costed 2 lakhs.
Maybe, my lord, I heard, my lord, it is too costly, my lord.
Huh?
Very costly in Arunachal Pradesh, my lord.
But you are benefited by around
Yes,
10
my
lakh,
lord.
10 lakhs.
Truly,
So what are you doing for the bar? Not
High
today, Friday evening.
My lord.
Commitment. Mr. Panging, have you heard something?
I've heard.
Hearing may not be possible today. Okay. Well, is there any urgent matter? We'll give some dates. We have to complete because we are leaving day after tomorrow. We have to complete some judgments. Okay.